So thank you very much for joining us. You're very welcome. It's great to have you with us. Just I would remind all of us, including committee members, that you're welcome to use mobile devices, provided that they're on airplane mode and they're muted. And also you can connect to the Assembly Wi-Fi. Password details are available in the gallery rules. I should also say that it's not permitted to take photographs or record any part of the meeting. Members, it's proposed that the oral evidence session with the Victims of Crime Commissioner Designate, with the departmental officials from Access to Justice Directorate, and the session with the Bar of Northern Ireland and the Law Society of Northern Ireland will be recorded by Hansard. Are members content? Agreed? Agreed. Lovely, thank you. The other thing that I would say, as ever, is in terms of housekeeping, we are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to a matter under consideration. So any members who have interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest to wish to declare at this stage? No, I think that I will declare mine. I should declare that I have an immediate family member who is in the legal profession. And so we move on. Agenda item 1. I don't have any apologies. Does anybody else? No, I think we're all present anyway. And we have 2 members who are attending the meeting virtually. That would be Mr. Easton and Ms. Ennis, who have already confirmed that they can hear. So if we move to item 2, which is the draft minutes of the meeting held on the 29th of February, and could I take this opportunity to put on record my thanks to the Vice Chair for chairing that meeting in my absence. The minutes are found at pages 5 to 16 of your pack. Are members content that those minutes are a true reflection of the meeting?
Content?
Yeah.
That's lovely, then I will sign those. There are no matters arising that we have unless members have any issues. No? Okay, so agenda item 4, which is at page 19 of your pack, and I will just get that up. So members, Geraldine Hanna, who is the Victims of Crime Commissioner Designate, is going to be in attendance with us today to give us an introduction to her role as Commissioner and an overview of her findings, her strategic priorities and suggested actions to improve the experience and confidence of complainants and victims of crime in Northern Ireland. Geraldine, you're very welcome to the committee. Thank you for taking the time to come. We look forward to hearing what you have to say. You'll appreciate that we've got 3 briefings today. So if it was okay with you, if you could maybe keep your remarks to maybe 10 or 15 minutes, and that will afford us plenty of time to have some discussion at the end. Is that okay?
It is.
That's lovely. And thank you very much. Over to you.
Thank you, Chair, and good afternoon to you all. I'm really pleased to be with you all here this afternoon. Before I begin my short introductory remarks, I would like to play a short video with the Chair's permission.
Sure, of course.
If what happened to us is normal, then I'd take out an ad in the paper telling people not to do it.
I regret ever doing it. I was doing so much better before. I went to court.
Victims don't have the energy. They need more support.
Our lives will never be the same, and the perpetrator has got a few years in prison. As far as the judge is concerned, he's been a jolly good fellow for admitting it. It's we who were given a lifetime sentence.
In reporting it, I doubled the trauma. It was absolutely heart-wrenching. It destroyed our whole family.
People told me to do it, that I get justice, but it's not justice. It's awful. If anyone asked me now, I tell them not to do it.
I felt like the perpetrator throughout the court case.
No one listens and no one wants to do anything.
I'm not phoning the police again if something happens and going through this all over again.
I don't trust this system anymore. It ate me up, then spat me out. I felt like killing myself.
Thank you for allowing me to play that. I think there's no better way to understand how our criminal justice system treats victims of crime than by hearing the words of those victims themselves. And what their experience shows us is that victims' rights and needs are not valued in our criminal justice system. Despite our numerous strategies and fine words, the sad reality is that when the system is stretched, staff and budgets are under pressure, it is victim care that suffers. Now, it would be remiss of me not to acknowledge the sterling work undertaken by many dedicated staff and volunteers working across our justice system. Are the improvements that we have seen with the introduction of new initiatives such as registered intermediaries, remote evidence centres and legal advisors for sexual violence victims. However, in spite of these, we still too regularly hear feedback such as those voices you have just heard. A victim's experience and fulfilment of their rights is still all too reliant on the luck of which investigator, prosecutor, judge or other official that they may encounter. If victims' rights are to be truly embedded at the centre of our system, then we should see evidence of the consistent application of these rights at every stage with every victim. I'd like us to think of our system as a three-legged stool. So those three legs are the rights of the state, the rights of the defendant, and the rights of the victim. Currently, the rights of the state and the rights of the defendant are rightly supported and enforced, but the rights of victims are not, which leads us to an imbalance and a criminal justice system that is not only just damaging to victims of crime, but it's also ineffective. This is not a zero-sum issue. Properly enforcing the rights of victims does not negatively impact the rights of defendants or the state in our system, in the same way that enforcing the rights of the accused or the state need not impact on the rights of victims. The state has powerful advocates in our system to make sure their rights are enforced. Defendants, through legal representatives, have powerful advocates to make sure that their rights are enforced. Victims' rights, however, are not being enforced in the same way. There have been moves in the last decade to better support victims, including the Victim Charter, the appointment of victim champions, but there's still a huge imbalance. Now, part of the rationale in creating my office was in trying to give victims a voice and to make suggestions for improvements. But it is not something that can be, unfortunately, achieved by my office alone. It cannot simply be a tick box exercise. It will require the hard work and commitment of the department, the criminal justice bodies, many organisations and government as a whole. As the Justice Committee, you have an important role to play, and I want to work closely with you all. In terms of oversight and legislation, it is really positive that you're here. My door's always open if there's anything that you want to talk about, and I'm always happy to come to the committee if there are any specific issues you want to discuss in this forum. In the briefing paper, which I hope you all have a copy of, I have gone into a bit more detail about some of the key issues I have identified since taking up this post, and some of my suggestions about how we can improve the experience of victims of crime in this part of the world. But all of this should be seen through the overarching umbrella that our justice system just simply isn't enforcing or supporting the rights of victims of crime consistently. Now, unfortunately, there's no silver bullets. But dealing with these issues and safeguarding victims' rights isn't just something that is good to do or right to do, it is in fact critical. Our justice system relies on victims supporting prosecutions. We cannot have fair trials without it. A justice system that addresses the rights and needs of victims of crime is an effective justice system. And an effective justice system is something we all rely on. We cannot build a free, fair, prosperous society without it. Now, I know as a committee your focus will be on the department and the criminal justice system. However, I do want to note that victims' rights and needs are not just the preserve of the Justice Department. Many issues cut across government, especially health, education and communities. These issues go beyond government too, and I work with other agencies and non-governmental bodies to raise issues where they can be best addressed. This is everyone's business because we all need an effective justice system to feel free and safe. And finally, I know that there are significant funding pressures on our public purse. Our current system isn't built around victims, but supporting and resourcing initiatives that will help to protect and enforce victims' rights to protection, participation, support and redress should be seen as an investment. It helps to build a justice system which we can all rely on. Victims' rights aren't valued in our criminal justice system, but they should be, because it is only by valuing those rights, by matching our words with actions, that we can make sure we have a truly effective justice system. So I thank you for your time, and I'm happy to take any questions.
Thank you very much, Geraldine. The first one on the list is Doug.
Thank you, Chair. Geraldine, thank you. And I have to say that my meeting with you last week was one of those ones that kicked up so many questions. And I would really say to anybody who can sit down with you and have a free conversation with you, they really do get to understand some of the depths what I didn't know, which are really important. And I was going to ask you a couple of questions if I can, please, and I'm hoping this is maybe for the wider committee at all as well. But the victims and witnesses experience of Northern Ireland criminal justice system key findings 22-23. We've seen that, and the figures in it are stark. And going, the percentage of witnesses and victims going down from 68 to 58%, those who have been kept up to date with their case, is hard enough. But can you, or have you been able to fathom why on earth domestic violence and sexual crimes are not included in that statistic, which is unbelievable, and I didn't know this until you raised it with me?
So the Northern Ireland Victim and Witness Survey has been undertaken for many years in Northern Ireland. It used to be an annual survey from my memory, but due to resources, I believe, we now do it periodically. It doesn't include victims of domestic and sexual and violence, and also I think hate crime, as well as families bereaved by homicide. I think that's potentially because of fear of re-trauma of victims. I do have concerns that we don't survey those individuals, and that's why our current victim survey, which is live on our website, is for all victims of crime. I think it's really important, of course, when we interview victims, that we are sensitive to their needs and the potential impact. However, by leaving out such a vital swathe of users of the system, we're not able to keep up to date with the experience of that group, of those groups of individuals. And what I would also say for the committees, just understanding the majority of people who come and speak to my office are victims of domestic violence, sexual violence, and families bereaved by homicide. And their feedback, whilst on some occasions they're dealing with more specialist units, their response received can be better. We also find that those are the cases where there can be significant harm caused by engagement with our system because of the length of time. These cases tend to be more complex, they take longer to move through, so delay is a particular issue for them. And unfortunately, the longer a case takes to move through our justice system, the higher the likelihood someone's going to have a more difficult experience and being let down and fundamentally have their charter rights not met, and that's something that should be a concern for all of us.
I think it's really important for us as a committee as well, because if we remember, for those who were in this committee the last time we sat, we put great store in training for our judiciary and our police service to deal with those who are suffering from domestic abuse or from sexual crimes. And if we're at a stage now where we're not even recording them, then maybe they're not even coming forward, or maybe they are coming forward, but the engagement with the police means that they're not getting the service they want, and that's so therefore it's really important to capture that. I think it's really important to capture that figure, and I think it's outstanding. That we're not.
Yeah, I certainly would agree with you. And the other point that I would like to flag is around the whole issue of data. So obviously the survey is a broad survey that's undertaken. I think it's every 2 years at present, but data is important throughout the system, and you'll know from my briefing paper that it's one of the key priorities. For my term in office, we are not consistently recording the victim experience through our existing data, so we shouldn't have to rely solely on reports like this that come out every few years. We should be able to, at any point, be able to pull out the experience of and the outcomes of victims of all types of crime. Unfortunately, our systems are not haven't been built with victims at its centre, so therefore they count different things. The police count crimes and incidents. You have cases then whenever you get to prosecution. No, we can't count the number of civilian victims and witnesses in our system. Significantly as well, we can't break that down into the age, disability, certain characteristics which would potentially indicate poor performance in some areas. So data is a big issue. It's dull maybe for some people. I maybe get a little bit too interested in it. But without knowing what our performance is, how do we actually improve it, how do we ensure that any initiatives we put in is having the effect that we have or that we desire. So investment in data set and a victim data set across all of the justice system is a key area.
And just to finish on that one, I take it for the next victims of witness experience that we will be pushing the case that we have to include domestic abuse. And
I certainly would like to explore that with the department, and I suppose what I would say is that there has been some focused research. The department might be able to speak better on this, but there has been some targeted surveys of victims of certain crime types, like people bereaved by homicide a few years ago. But this survey is still.
And if you don't mind, Chair, just one more question, and that is, I have a real issue with lenient sentencing. I mean, I said this to you when I spoke to you. I think sometimes we have far too many lenient sentences, and I don't like this 50-50 model that we have of 50% in prison and 50% on licence. I don't like it, but that's where we are at the minute. But your thoughts on remission? That somebody can go through a trial, use all of the police resources, use all of the court resources, all of the time, the effort, the money, and on the day of the trial, admit guilt and get a third remission, which I think is just diabolical, to be honest. What your thoughts on that, Johnny?
So for some of the victims speaking to us where they have got as far as a sentence, the reduction given for what is termed an early guilty plea is of significant concern. Those victims, particularly the language we use around it, we tend to use the term credit or discount. Victims find that offensive. They also, the rationale underpinning early guilty pleas is to save the state money, and also in recognition of the fact that the victim will then not have to go through the experience of giving evidence. The closer that gets to the actual trial date, the more offensive that is to victims that someone will receive any reduction. I think that's something that we really need to look at. Of course, we want to encourage guilty people to plead guilty at the earliest opportunity. This isn't about putting pressure on people who aren't guilty to plead guilty. Not at all. It's about those who are guilty pleading guilty earlier. But when that comes to close to the week before or on the day of trial, which it is in some situations, that is offensive. It also, for some victims, they may on the day be relieved that they don't have to go in and give evidence. But in the months afterwards, when they're speaking to me, they're then look at the sentence and wonder, was it worth it? So it's definitely an error.
And Charles Little is a prime example of that. Somebody who wanted that day in court, who wanted to hear the evidence, I think it's a genuine issue. I think it's an issue that can be fixed. I think if we put our minds to it. But thank you very much. Thank you, Joe.
Thank you, Don. Stuart.
Firstly, apologies for stepping in and out. I was doing a GP appointment. Apologies. Thank you for your presentation and for the work that you do. Could you perhaps tell us how you feel that through your role we can build a better victims of crime centred justice system?
So real plug then for my role. Obviously, I think that this office is a good step forward in terms of recognising the rights and needs of victims of crime. But as I said in my opening remarks, it's not enough in and of itself. The importance of this role really, I think, links to the champion for those victims' rights. As I said when I talked about that three-legged stool, we need more voices advocating for the rights and needs of victims, and this office, once it's placed in statute, so at the moment it doesn't have the powers of the office, and hopefully it'll never need to rely on the powers, because I'd like to think that the office will always foster positive engagement with the criminal justice agencies and beyond. But by having a statutory commissioner for victims of crime, I think victims can be assured of that independent voice that is able to act as a constructive friend to government and the Justice Department, to highlight issues and really draw attention to their experience, because sometimes they very often do feel that they are bystanders in our system. So we need an agency and a voice there complementing all the other agencies, and particularly, I think of the community and voluntary sector and the important role that they play in that as well. But this office certainly can help harness that and hopefully act as a positive tool for the justice to progress, but for the government to rely on for advice and support. and hopefully constructive challenge as well, where we think that we can always do better.
Just very briefly, just a couple of points to raise again, and thank you for that. That's been very, very helpful. You made reference to one aspect that is of tremendous benefit to victims of crime, particularly very vulnerable victims of crime, and that's remote access to the justice system. How important a tool do you consider that to be in the delivery of support? The other area I want to raise with you is one which I remember from my previous time in the Justice Committee, was this the difficulty that many victims have around the subject of understanding that the prosecution service is not there for them. It's there to prosecute on behalf of the state for the crime that has been committed. And many victims find that very difficult when it comes to the legal interface. So what work will you be doing to improve that legal interface?
With regards to the first question, the remote evidence is a key development for victims in terms of trying to minimise the trauma. What's clear in our victim charter is that we will protect the victim from contact with the alleged perpetrator wherever possible. Remote and live link evidence is key to that. So it's really important from my perspective that we have legislation in place to govern that. During the pandemic, that provision was extended in order to enable people to be able to give evidence under the direction of the judge. So it doesn't necessarily need the full hearing where defence and prosecution will argue whether or not it should happen. That has been extremely helpful and is something that I'm really encouraged that we still have in place with regards to the access, the remote access for victims. Where that is really prevalent or really helpful at the moment is as we roll out remote evidence centres, particularly where we have a child given evidence from a remote evidence centre and their parent is a witness as well in the case. The ability for that parent to be able to give evidence from the remote evidence centre so they're not separated from their child is paramount to their experience and feelings of safety. Unfortunately, I do have some examples where the parent has not been permitted to give evidence from a remote evidence centre, which means that the child then was brought to the court as well, which is something we all want to avoid. So that provision to be able to give evidence remotely easily and that it's accessible to people is important. With regards to the victim's experience of the justice system and the fact that, back to that three-legged stool, whenever it comes to the actual justice system, the two parties at play are the prosecution representing the state and the accused in the trial. And for most people, that is news to them and is really quite upsetting when they realise it. So victims very often report being angry that at the police station they're asking, where's my solicitor? Should I get a solicitor? Do I need a solicitor? Told they don't need a solicitor. And that's where the fact that they're not party to proceedings causes particular issues. Part of my role is to engage with voluntary organisations as well, trying to improve the information that's available to victims and also the support available to victims. I think whenever it comes to the fact that that victims aren't party to proceedings, there are some aspects of that I think we can further build on. We've started with the introduction of victim advocates and legal advisors in sexual violence cases to do with their Article 8 rights. That was, as you will be aware, a recommendation of Gillen, but any place where we can ensure that the specific rights, particularly around issues such as Article 8, are being impacted, I think it is important that we look at what legal provision can be provided to assist victims. I'm certainly by no means saying that victims need an advocate standing up in the court in the same way as you have the prosecutor alongside the defence, but any places where we can increase the opportunity for victims to participate and be made fully aware of what their rights are, and that we have advocates for those rights. That's where work such as Assist NI, where the domestic and sexual violence advocates play a big role, as well as the SOLA service.
Thank you, Chair.
Morris.
Thank you, Chair.
Thanks very much for your presentation, Charlie. Certainly an eye-opener for me as a new member of this committee. What I get from the public is a grave concern about the delay from the crime being committed to it actually appearing in court. So how can you deal with that? And also, as Doug has alluded to there, the offence itself, when it does get the length of court, quite often it's a very lenient sentence, which doesn't reflect the gravity of the crime committed in the first instance.
You've raised two issues which are raised regularly with myself. The issue of delay is one that obviously has plagued our system for decades now. I know that this is a key priority for the Minister in the Justice Department and the Criminal Justice Board, and there is work which no doubt the people coming after me will speak to in more detail. From my perspective, I would like us to see greater accountability and transparency around that work. I would like to see a published reform plan, so there is an action plan around delay. I would like to see that available on the Justice website so that we can all see what we're prioritising and the progress that's being made against it. I think it's really important when we look at this issue that we look at the system as a whole. The criminal justice system may be made up of independent agencies, but they're also closely interconnected, that from a victim's perspective they see their journey from the time that the crime happened right through to post-sentencing and beyond in terms of their recovery. So it's really important when we are looking at this issue that we examine what initiatives are needed on a holistic basis, because we can prioritise resourcing in one area. So, for example, if we had lots of great laws and loads of police out investigating and detecting crime without looking at the prosecution side and prison side, we're going to end up with backlogs and bottlenecks in our system. So we need to approach this from a holistic perspective, and I think there is recognition around the department in that, but I would like to see that more publicly available so that we can all monitor it, and because delay is a significant issue, and for some victims who I'm meeting with, you know, you're talking 4 or 5 years. The impact on their mental health in particular in that is devastating. Then the other issue around lenient sentencing, there is a perception from victims about sentencing, and I do hear that, and I believe that it's very difficult to comment on an individual sentence because it's so complex and there's a lot of aggravating and mitigating factors that we need to consider. That's why judges are so well placed to do this. But there's also an understanding as to how sentencing works, which I think we need to educate the public on. But there's a perception as well that whilst, of course, sentencing has rehabilitative purpose, and we need to ensure that we work to address the behaviour to prevent it happening again for future victims. There's always in every one of these cases a victim today, and they want to feel that they're having effective redress for the harm that was caused to them. And sometimes those headlines that we see around sentences given don't leave victims feeling that they have had that effective redress, and that's something that I think we all need to consider.
Okay. Can I just listen, it's not just the victims who have got concern about lenient sentences, it's also the PSNI officers who go through an awful lot of hard work to get a case to court to find out it's a slap on the wrist. It's actually a slap in the face to them as well. The other thing, there's some things I do in this machine here which will automatically transfer to my Mac in the office and the Mac in the office in Coleraine. So data sharing is easy. So why is it not happening?
So with regards to the system, the data sharing across the system for me is challenged because we don't have one system that everybody's using. We do have Causeway, which again, I'm not an IT expert and I haven't ever seen Causeway in action, but I understand a lot of information goes into it. I think there's issues there around what better information could be in there and also the quality of that information. For me, we need to be having clear data dictionaries as to what everybody's capturing, that it's the same thing, and that we're able to track that journey throughout. I think at the moment the challenges are the systems don't speak to each other in as an effective way as they should, and that requires investment.
Thank you, Chair. Thank you.
Morris. Alex?
Hi, can you hear me now? Yeah.
Yes.
Yeah. Thank you very much for your presentation. I was reading through it there and about the Victims Charter, that you don't have process to monitor all agencies and their compliance with that. Can you explain why that's the case? And is it anything to do with your staffing levels? Because I noticed that you only have 5, which probably isn't adequate for you. Is that something that we could maybe put pressure on the Justice Minister to maybe help you out with?
Thank you. When it comes to the Charter, as I said in the briefing paper, it was enshrined in legislation in 2015. Now, the Criminal Justice Inspection in 2020 found that there was a lack of understanding of the Charter, not just amongst victims, but also amongst our criminal justice agencies. And the quote is along the lines of there was a sense of apathy and disconnection between the professionals working in the system and their understanding of their obligations under the Charter. Now, part of my role in this new office is to monitor compliance. The challenge I have is that the agencies themselves are not monitoring that compliance. And that seems to be because their systems haven't been set up to do so. But there has been, in my opinion, limited efforts taken to enable that. I'm now, as part with the team that I have, working with the criminal justice organisations to see if we can agree a common data set that they can help that they can complete to help us monitor that. Resources will be an issue, and whilst there's 5 in the office as part of my office at the moment, I do hope that whenever this office is placed on a statutory footing, that those resources will be increased, because monitoring compliance with the Charter is a key way, in my view, to ensure that people understand. So that apathy and disconnection that the CJNE found when they looked at this issue, I hope that will be addressed more if people are required to basically keep track of when we're delivering it. It's that old adage, what gets measured gets done, and one of the ways I believe that we can help embed that in the mindsets of all of our criminal justice practitioners is to ensure that there's reporting mechanisms. That will help us see what the situation looks like now, where we need to improve, and hopefully monitor any initiatives to see have they actually had the intended consequences that we hope for.
Okay, thank you.
Thanks, Alex. Deirdre?
Yeah, thanks very much, Charlene. And I'm sure we'll be seeing more of you over the next period. The report, I suppose it sets it in contrast when you say in the report during the period of 22-23, 69% of all crimes actually had a victim attached to it. So it shows the scale and numbers that we're dealing with when you think over 100,000 in that year had went through the system in terms of reported crimes as well. So the first thing I was going to ask, was building on the last point, was around in terms of having a statutory footing, what additional powers or functions, if any, would you see the Office of Commissioner holding?
Thank you. And I think your point's well made in terms of the numbers of people attached to it, because with both that 69%, you don't only just have the direct victim, you have everybody associated with that, so it has a profound impact. In terms of the statutory footing of the office, I would like to see us very much mirror similar powers that are in place for the Domestic Abuse Commissioner and Victims Commissioner in England and Wales. I think that the office, whilst hopefully never having to rely too much on its powers, but I think it should be able to compel agencies in terms of responding to recommendations. I think the office should be required to produce a report for the Assembly, so not just for the Justice Department but for the Assembly, on an annual basis on the experience and treatment of victims and witnesses. I also think that, going back to the point about the Charter, that the office should be required to produce a report periodically, so that maybe every few years, around compliance with the Charter and improvements that are being made. I do think that the office should have some power to be able to potentially undertake a judicial review or conduct, intervene in a case. Whilst I think it's probably resource-wise too much for the office to be able to intervene in every individual case, given the numbers we're talking about. I think where there's thematic issues, we could be able to use an individual case to prove a point in law. Hopefully you'll never get to that point, but it's important that when we set up this office, that it has the effective powers to be meaningful, that it isn't just a tick box exercise, because victims feel very much that they are an afterthought. And whilst it's great to have the title of the office, it needs to have enough teeth really for it to make a difference. Otherwise, it would be just lots of fine words. Yeah. But we need more actions.
And your relationship then with the departments and the different strands within the overall justice family, how do you feel that is, or what could be improved in terms of the relationships and posts going forward?
So the relationships to date, I have to say, are very positive, and the office currently is sponsored by the Department of Justice. I think that you can see where it neatly falls there. The criminal justice system has a particular impact on victims' lives. I think that this office powers, though, should be broader than just justice, because it does incorporate so much, particularly when we think of health and mental health in particular. Mm-hmm. As well as communities and education. Every one of the departments I could see, I see a link to, which is why I think that the powers should be broader than just justice. The relationships to date have been positive. The department, I think, my background is I've worked in this area for some time, so I know a lot of the officials well, which I think has been helpful, particularly as I've been set up as a designate. So I'd like to think that my previous relationships has helped me open doors there, because people will be used to me. I'm sure they would have been nice to everybody else as well, but it is positive. I think no doubt as the office grows and we have more reports and that evidence piece, there will be times where we have creative tension, I would like to say, with the departments, but certainly to date, and with the Assembly being back, I've written to each of the ministers introducing the role of the office and wishing to speak to them all at appropriate times around issues that impact on victims that are within the purview of their offices.
Yeah, no, and I could ask you a million questions, but I'll try and summarise some of these, because we'll probably want to come back particularly around issues like disclosure that you touch on, which I think is a huge issue that we need to be looking at. Obviously the delay within the system, and it's not just you saying this, even in the subsequent reports we're going to be getting around delays, the kind of siloed approach of the system, funding obviously being a huge issue and pressure as well. But you talked about the victim journey, and also that the system wasn't designed for victims either. And it just made me think of even just, I suppose, bigger cases that you would know around institutional abuse, around mother and baby homes more widely, around even legacy families, and in terms of how those victims feel and have felt in terms of how the system has responded to their needs as well. And as opposed to try and front load it then, notwithstanding the funding pressures and difficulties, or taking that into account, what areas would you prioritise in terms of improving that journey from victims in terms of first reporting, which may be the PSNI in the first case, and taking it right through their journey? How would you see that improved? And if you could just talk a wee bit around what you mean in terms of the system not being designed for victims, and if you could design a system, some of your thoughts on that. Thank you.
Broad range of
Sorry.
It's okay, and I could talk to you all day
back,
about it
so,
as well.
yeah.
I could keep you here for the rest of the afternoon and beyond.
Except two other presentations.
But with regards to areas to prioritise, for me, the fundamental building blocks of victim support are needs assessment and advocacy. We promise our victims in the Victim Charter that they will have an individual needs assessment, and we promise a tailored service. That's not what I'm hearing from victims who speak to me. I am disappointed that the Criminal Justice Inspection Report in 2020 recommendation around a needs assessment has not been progressed because of funding issues. I appreciate the funding issues. I appreciate that the department are in a difficult position. and no doubt you will hear with people coming after me as well, we are all aware that this area has been chronically underfunded for decades, and unfortunately, from my perspective, victims are feeling that. But needs assessment is important. It's significant. In order to appropriately respond to someone who has been harmed through crime, in order to appropriately meet their needs as they journey through a justice system which has not been set up for them, and in many respects, research will show can cause further trauma. We need to understand that individual's needs and respond appropriately, and that's where the advocacy piece comes in. So those are the areas where I would really prioritise. Individually assess a need and then responding appropriately in order to meet that need. There are legislative pieces as well, and you refer to the disclosure paper. That was an immediate priority for me because it was, again, the first issue that really hit my desk in the first week with the very first victim who crossed the desk, so to speak. And it's an issue that we have long known about in the system. That report highlighted that we have issues around compliance with existing rules, and that's back to this advocacy piece as well. Who's calling that out? Who's ensuring those rights or needs are met? But it also highlights issues around increased safeguards needed. So I want to see changes to the law that requires the commitment of people like yourselves and the wider Assembly. So I really hope to work with you on that because, again, there is work that we can be done. Some of that's around funding. Some of it's also around back to basics and people recognising that whilst even when you don't face-to-face engage with a victim, people working in our system, their decision makings can impact on victims. So that's a training piece, it's a cultural piece, and we all need to be sending out the message that victims' rights are as important as defendants' rights, are as important as the state's rights, and we should all be ensuring that we're fighting to protect those.
Thank you.
Thanks.
Okay. Thank you, Chair, and welcome, Geraldine. Obviously, you've answered my question was clearly in relation to the needs assessment. Obviously, first and foremost, it was really powerful presentation today, particularly in relation to the voices of victims, and so thank you for that. And obviously, we need to ensure, as you mentioned, it needs to be victim-centred, and obviously your report was very succinct in relation to 3 key areas as data disclosure and delays. Obviously, compliance to the charter, obviously integral, and then obviously, as you've just discussed there now, is the needs assessment. In relation to the needs assessment, and obviously that's critical, we can have a lot of bureaucratic things that need required, collaboration, a cultural shift, and supporting organisations to work collectively together, but that takes longer. However, the likes of a needs assessment with advocacy from the start, and it's a wraparound, could very much support the cultural shift and the change and support organisations to make that change. So you had mentioned in your report, obviously, that you were hoping to meet with the Minister for Health shortly in the discussions. How would you see the likes of this assessment being done within a centre, and what cross-departmentally, how do you think it could work? Have you any thoughts on that?
So first and foremost, with the needs assessment piece that's been recommended through the Criminal Justice Inspection report, where that is proposed to be housed is within the Victim and Witness Care Unit. Now, the Victim and Witness Care Unit is jointly staffed by PPS and PSNI, but it also currently has, I think it's 2 members of staff assigned from victim support. The proposal for the Needs Assessment Service would expand that so that there was a needs assessment team within the Victim and Witness Care Unit. And how I would see it working is you report a crime to the police. The police put your details onto the system, onto their niche system, as it's called. The Victim and Witness Care Unit Needs Assessment team contact you. Now, dependent on that, how that approach will be made will be dependent on an initial triage. So you will do a crude assessment, as I would say at that point, triaged based on probably age, crime type. So you imagine victims of domestic sexual abuse will get a phone call. If it's criminal damage without any domestic motivation or hate crime motivation, it may get an email or a letter to the individual to say, this crime has been reported, we would like to undertake a needs assessment with you. That team member then would undertake the needs assessment at that point, and that would cover not just what the person needs to engage with our criminal justice journey, but what needs they need with relation to referral to other organisations and support services. When health comes into it, that's going to be where our big challenge is, because, and I appreciate that once we, I'm going to be optimistic, once we have a needs assessment in place, the challenge is going to be meeting those needs, because we are going to identify gaps, particularly gaps around mental health support and waiting lists. But back to what I said earlier, we need to quantify what the issues are. That gives us a business case for investment, so we shouldn't be afraid of coming out the results from needs assessment showing that there is a lack of mental health support for victims of non-domestic or sexual abuse in broad certain counties of this area. That shouldn't be feared. That should be shown as, okay, well, if we're doing it better in one area, why can't we do it in the other? That will help give the evidence, and so much of this, ironically, in our justice system comes down to presenting the evidence. So that needs assessment is key, but alongside it, you need the advocate who is aware of what services are available and can champion where rights aren't being met. So people aren't getting updates. If they're sitting within the victim and witness care unit, they will be able to contact the officer in the case to find out what's happening, or to send an alert. That's why having them embedded within the victim and witness care unit is going to be so key, because they will be able to have access to systems. And it's back to the point Maurice said, was about why isn't this data being easily shared? It's because the systems aren't talking to each other, and access to those systems in order to ensure, again, GDPR is met, information security concerns are appropriately met. Having vetted staff based within that care unit, I think, should assist with that.
I'd just like to make one comment, and it's obviously it is a wraparound, and their models already exist across the health service and the likes of family support hubs, health hubs, mental health hubs. So these hubs exist to provide a wraparound service at first point of contact. So and it's back to basics.
Yes,
and so it's not complicated. It's back to basics, and as you say, it's putting the victim at the centre. So I really would like to encourage as much support for this intervention, and I think it's critical, and it can support the whole system and all organisations working in the system, but likewise putting the victim first. So thank you for the update.
I'm just conscious of time because we're already overrun somewhat. So Justin.
Thank you, Chair. And thank you very much, Geraldine, and for your obvious empathy and compassion for the needs of victims. It's crucial for somebody in your position to have that human sense for people. It's heart-wrenching to hear the testimonies of the victims, and as Ciara said, that human voice, it was heart-wrenching to hear that, and sad that it reflects our justice system as it is. You said in terms of the data, what gets measured gets done. If you're not assessing, you're guessing. These systems were never set up with the victim in mind. Serious lack of useful data. What was the system set up with in mind?
I think that the systems, each agency has approached its system in terms of its own performance needs. So with the police, it very much focuses on the numbers of incidents. There will be information in there around case, like investigation progress. With the PPS, it will take it as a case, and it will look very much at where that case is in the system. If you were building a system from the perspective of a victim, you would start from crime happens, report to police, needs assessment hopefully being undertaken, and what those needs are. Then you would, if in the justice perspective, you would look at when they got an update, recording what those updates were. Where a victim has raised a query or concern, that should be on the system. Significantly, where victims withdraw support for a prosecution. So at the moment we do capture in the police side, but not on the PPS side. We don't statistically report on that. But the police will report in their quarterly statistics around victims withdrawing support from the prosecution. But significantly for me, they don't report why, because they don't have a field where they put that in, so it's a free text box. So we know that in sexual violence cases, around 40% of people withdraw, cases don't proceed because victim has withdrawn support for the prosecution. But I can't tell you why that is. Now, I can tell you it's going to be things around delay, about the impact of their mental health, about other factors in their life coming in that means that they can no longer remain committed, that they lose faith in the system. Lots of different reasons. Intimidation, that can all be part of it. But I can't tell you what percentage falls under each of those categories. So therefore, with all the initiatives that we put in place and try to give better support, I can't be able to say, look, we can see that impacting on that. So that's what I mean when it's not built around the victim. We're not capturing victims' outcomes and victims' experience through that consistently at each point, which means it's harder then to report, which means an office such as mine has to then go and do an investigation research piece into it, which takes longer, all of this is only off the time at which the research is undertaken. So having a consistent victim data set built into our system that's regularly is updated in live time helps us to improve the performance of the system.
Thank you, Geraldine. In terms of the courts and tribunal service, the backlog, when will that get beyond the pre-COVID backlog?
Might not be a question for the Commissioner to answer.
Yeah, I'll in terms of appropriately answering that, it would be courts and the department maybe who would be best placed. The last I heard, we were looking at April of this year, but I'm not sure if that's still
just in actually our next presentation. Actually, that might be a useful question. Geraldine, I apologise because we have run out of time, and I appreciate that members had a significant number of questions. I had 8, but I will let it go. I suppose there's just a couple of things that that are my takeaways from today. I think it'd be interesting to have further conversations around the extent to which the loss of confidence from victims stems from the system itself and what happens versus the sentence at the end of it. I think that would be useful to know. I'm also keen to have some greater understanding about the Victim Information Scheme because I was not aware that sexual violence, domestic violence and homicide were not eligible for part of that scheme.
Sorry, that's I maybe haven't framed that right. It's not, they are eligible. The issue that's being raised with relation to the Victim Information Scheme is when, so if, for example, I had one person come to speak to me, there'd been a victim of rape. They signed up for the Victim Information Scheme. The person was found guilty. They were able to be updated. That person was then released from prison and went on to repeat offend. They seen from the media that the person was in prison again, but they're not allowed to be kept updated as to what happens then. The person lives in their area, so there's probably a smaller number of people who this may impact on, but when it impacts on you, it is profound because it's around your safety and well-being. So in domestic and sexual abuse in particular, those are the issues where it's been raised, where someone's went on to repeat offend, but you're not allowed to know when that person is next being released from prison.
Understood. Yes, that's helpful. And actually, I think for further conversations, I think that the data recording is of interest because I suppose there are issues around the recording of repeat victims. I also would like, I suppose, some further information. You've made some recommendations as to whether or not you've kind of conducted any rough cost of recommendations, and also you mentioned strengthening legislation. I think at some stage I would like to hear from you in what way you would like to see that happen. I suppose from my point of view, I think what we're all here for is to ensure that there is a better justice system for society in Northern Ireland, whether that be the victim, the defendant, but society as a whole. And the one thing that everybody must be able to take confidence in is the system itself and due process, and that everybody considers that they have been treated fairly. So I suppose what we need to do is find the balance between ensuring that the victims get their needs and the support that they require addressed, but it's also very difficult in circumstances where sometimes people have been accused of things but they're innocent. So we've got to find that balance, and the key here is making sure that we can, all of us, have as much confidence in due process as is possible. Geraldine, could I thank you very much for your time? It's been really informative for all of us. I'm sure we will converse further as things move ahead, and we're grateful for your attendance here today. Thank you very much indeed.
Thank you very much.
Thank you.
Please.
Members, I'm conscious that we are slightly behind schedule, so where possible I'd be keen that it's not my nature to try and curtail questions, because I think there are issues that we do need to drill down into, but I think that we'll have to be conscious that we're behind from our first presentation, and the further behind we go, the longer we're keeping those at the end waiting. But I have no desire to stymie conversation or questioning. Okay, members, if we can move to agenda item 5, which is an overview of an overview briefing on the Access to Justice Directorate, and that is at page 35 in your packs, running to page 69. So we have officials from the Access to Justice Directorate from the Department of Justice, and they're going to give us an overview of that directorate. So as far as I know, and from this distance I can't see all the nameplates, but I am advised that we've got Sean Holland, who is the Sean, he has the Director of Access of the Directorate Access to Justice. We have Lisa Rocks. Yes. Hi Lisa, who is the Deputy Director of the Justice Performance Team. Julie Wilson. Julie, who is the Deputy Director of the Victim Support Division. Maura Campbell, who I know, hello Maura, Deputy Director of the Criminal Justice and Legislation Division. And last but not least, Andrew Dawson, who is the Deputy Director of the Civil Justice and Judicial Policy Division. Again, obviously, it's great to have you with us. We look forward to hearing what you have to say. I'm conscious that there are 5 of you and 9 of us with questions. So maybe if we could work on the basis of a 15-minute presentation and 30 minutes for questions, or 10 to 15 minutes of presentation, because I think we're eager to get into the meat of a discussion. So I will hand over to you to give us your briefing, and then we'll take it from there. Thank you very much.
Thank you very much, Chair, and hopefully we'll come in well under 10 minutes. I think the questions are probably the most important part of this. Thank you very much for inviting us here today. I'm really grateful to have the opportunity to speak to you today and provide some detail about the work of the Access to Justice Directorate within the department. But before I do so, I'd like to echo what Richard Pengelly, the Permanent Secretary, said to you a few weeks ago when he appeared here as well. Our desire is absolutely to work in an open, engaged and collaborative manner with this committee. We value and respect the vital role this committee, and indeed all committees of this Assembly, undertake on behalf of the public in subjecting our work to scrutiny, as well as the insights and views of the members of the committee on our work. When Richard spoke to you, he highlighted the challenges facing the department, and you've already had reference to it in relation to the financial position. It's the financial position the executive as a whole faces. In his presentation, he focused on the largest areas of expenditure that the department face, which are therefore where our greatest pressures are: policing and prisons. Now, these are demand-led areas of justice activity. They're regulated, they're underpinned by statutory duties and obligations, and much of the spend associated with them is absolutely non-discretionary. Inevitably, that means that those areas of our activity which are about innovating and improving, transforming and extending services, fall into the could do, should do, rather than the must do, at least in terms of financial accounting and reporting. Much of the work of Access to Justice, such as improving the experience of victims or seeking to increase protections for vulnerable members of society through either new offences being created or extending services or creating new services, can fall into those categories of non-discretionary spend. And that means they particularly struggle in times of constrained resources. I know that change generally and the needs of victims and the protection of the vulnerable are of interest to this committee. That interest is absolutely shared by the Minister and will be vital given the challenges that we face, having the interest and support of the committee when we face the struggle to try and create a sustainable resource base for the delivery of justice. In addition to finance, one of the other major challenges we face is the limited time available in this mandate and its impact on the legislative programme that could be taken forward. And we particularly value the role of the committee in relation to the passage of new legislation. And we know that given the shortened mandate, this is an area where we are going to have to work as closely as possible if we're going to make the most of the limited time available to us. If it's acceptable, Chair, I'd now like to introduce the team with a brief overview of their areas of responsibility, and then we'll get into the questions. The Access to Justice Directorate overall aims to deliver improvement to the criminal and civil justice system. It's doing that by working in partnership with a range of internal and external stakeholders, including obviously the Designated Victims Commissioner you've been hearing from. Our intention is to try and improve the law, policies and procedures to benefit victims, witnesses, defendants, staff, the judiciary and wider society, to increase effectiveness and secure confidence in the justice system, which you've just referred to, Chair. The Directorate also sponsors the Criminal Justice Inspection for Northern Ireland, which is a non-departmental body. Particularly, we've got four divisions. The Justice Performance Team, which is led by Lisa Rocks. Its main areas of responsibility include supporting and coordinating work on speeding up justice, again been referred to already, managing the existing Causeway IT system and taking forward for its re-procurement. Causeway is the integrated messaging system that allows various criminal justice organisations to talk to each other and share information relating to individuals who are progressing through that system. Her division also provides the Secretariat to the Criminal Justice Board, and I would at this point like to apologise for an inaccuracy in your pack, which notes the early engagement reviews recommendations as being made in relation to the Criminal Justice Inspection Report regarding avoidable delay. That actually refers to a Northern Ireland audit report, and I apologise for that error. The Victim Support Division is led by Julie Wilson. This division takes the lead on supporting victims and witnesses through their involvement with the criminal justice system. It also has specific responsibility for the implementation of the recommendations of the Gillen Review, led by Sir John Gillen in 2018, into serious sexual offences. Then we have the Criminal Justice and Legislation, Criminal Justice Policy and Legislation Division, which is led by Maura Campbell. Maura's division oversees the department's primary legislation programme and provides an advisory role to other departments and Whitehall departments on any proposed changes to the criminal law as they may have effects in Northern Ireland. They take the lead on a wide range of policy areas such as sentencing, sexual offences, miscarriages of justice, including litigation impacting on any of those related areas. This division is also the sponsor branch for SIGINI, the Criminal Justice Inspection, and oversees the governance of the Coroner's Legacy Inquest Project. And then we have finally the Civil Justice and Judicial Policy Division led by Andrew Dawson. Andrew's division is responsible for policy and legislation relating to the structure and jurisdiction of the civil courts and those tribunals which are under the responsibility of the Department of Justice. Also private law policy implications for Northern Ireland that arise from any international obligations from conventions and treaties. That's the team. Those are our areas of responsibility. So now to the other part.
Thank you very much, Sean. Deirdre, you want in?
Yeah, no, thanks very much for the presentation. Again, you had touched on in your report in terms of looking at the causes of delay about inefficient practices and processes during the early stages of the investigation, and also the inability of justice organisations to commit to a collaborative working model. So it's just to see what you have identified as the barriers and also the potential solutions to address some of these fundamental issues.
Okay, well that's a piece of work which is ongoing. It's a priority for the department, and it's also a priority for the Criminal Justice Board, who have made it their main focus of work, speeding up justice. Specifically in relation to early engagement, we have a work stream being led through the Criminal Justice Board focusing on early engagement, which aims at improving collaboration and cooperation to ensure that those delays which can be avoided at the point of a case reaching trial are dealt with before trial. I'm going to look to Lisa from the Justice Performance Team, who sponsors that work.
Yeah, and I suppose it's important to recognise that in the area of delay, there's a range of factors. So an element of a programme that has been developed with Criminal Justice Board is looking at things like what are the demands placed on the system. So actually, are there things going into the court system that could be dealt with in other areas? There's also then obviously the practices of which you speak, and looking at those. So the Criminal Justice Board have developed a 5 work stream approach, so a wider programme of work, which is split down into looking at things like out of court disposals to take those out of the system, and looking at things like committal reform, early engagement, as Sean has mentioned, and the sort of digital work stream. So I suppose a combination of those things is trying to make sure that ultimately the programme will deliver a system where the most serious cases get to the Crown at a sooner point. In terms of the work streams, they're sort of sponsored by each member of the Criminal Justice Board, so there will be a key bit of work at the earliest stage in a case where it is that interface between the PSNI and the Public Prosecution Service. So there's a body of work through the Working Together Board that will also look at that in detail. So I suppose it's sort of a long way of saying that there's quite a range of things being done. In terms of the collaborative piece, one of the things we saw was there was a body of work done before COVID had hit. So the department had made some progress in reducing the end-to-end case processing times, but COVID, like everything, created a bit of delay. But if we were to look at one of the very small benefits of it, would have been that actually it drove a lot more of that collaboration. So the Criminal Justice Board came much more collaborative in dealing with the recovery of the system post-COVID, and then that has now morphed into a Speeding Up Justice programme, which is very much in separate work streams and is being driven forward as a programme of work.
I suppose just one more and then I'll stop. It's a quick one, just around a reform plan that was touched on just by the Commissioner earlier. Will this be published?
We are looking at publishing it. At this point, we haven't got to the point of having a full tied down programme in terms of sort of tasks, and there's a lot of sort of stakeholder engagement to be done, and I know the Victims Crime Commissioner is one of the people that will be part of that, but the ultimate aspiration would be to do that. And also I think it's really important in the end-to-end time of, we talk about the courts being very slow, but actually there's a piece about there are 5 stages in the process, and ultimately we would like to get to a place of saying, well, here are the 5 stages, here are the interventions that we will make as part of that programme. And actually a really key bit will be, and touching on the data, actually what do we want to see, what are the measures that we will see that will show how we have driven that positive change.
Do you hear I've got a list?
It's just on this point.
It's
actually just on this point, and you mentioned your work streams, and it's a very systematic approach, obviously, to speed up the system. Could you just look, where is the individual, the victim, in this speeding up your process? Where are they within that development?
Well, absolutely. Everything that the programme is about speeding up the system overall, and as the Chair has mentioned, for the benefit of all, including the victim and the defendant in the process. I suppose there are bits of the programme that will take longer to deliver. So the data work stream will look at what victim data is captured, because I suppose one of the other areas that I'm responsible for is the causeway system, and the causeway system as it is currently designed is tracking a case on a defendant from end to end as it goes from each criminal justice organisation, but what it doesn't currently capture is victim data. So that's one of the things that we know as part of the next digital iteration. We need to start expanding our thinking around how do we link that through, how do we look at the victim journey. I suppose also the bits of work that have been delivered in the programme, for example, the abolition of oral evidence has been a big element of what we have delivered in terms of ensuring that the victim doesn't have to give oral evidence twice going through the process. So as that programme develops, the victim and the engagement with the Victims Crime Commissioner's Office will be a fundamental part, because the victim is at the heart of what we're seeking to do.
I think it's also important to add that speeding up justice is obviously crucial to the interests of victims, and it's something they complain about repeatedly, but it's not the only issue for victims. And we have a wider programme of work led by Julie, which is about trying to improve the experience of victims and increase their representation and their voice within the justice system. And Julie can answer questions to that. Also specifically, Jerry, the Commissioner Designate, has attended the Criminal Justice Board and will attend the Criminal Justice Board on a regular basis to represent the views of victims in that particular work stream. But as I say, there's a much wider programme of work in relation to trying to support victims beyond the Speeding Up Justice programme, although we recognise it's absolutely central to victims' interest to speed up the justice programme.
Oh, that's good to hear that they are absolutely central to any systematic approach for change. Oh, thank you.
Cheers.
Just a brief and rather niche question, and I appreciate the need to sort of try and keep the business moving today, Chair. The Criminal Justice Review under Lord Justice Gillen looked at a wide range of topics. One of them is in relation to personal injury and the cost of car insurance. Now, it's a topical issue at the moment in Northern Ireland as people get their car insurance bills. My understanding is that we are somewhat out of step when it comes to calculation of compensation, and I'm just interested to know where the department is in terms of the implementation of the recommendations of Gillen in respect of personal injuries.
So I deal with the niche areas, so I'll answer this one. It's I suppose we're not particularly far ahead in relation to those recommendations from the Gillen Review. I suppose what we have ongoing at the moment, which touches on this, is the upcoming review of the personal injury discount rate, which is a statutory requirement that we need to do, and we'll be briefing you in full on that. In terms of the Gillen reviews on insurance, I don't actually. I think they may fall to another area of the department. I'm not entirely sure, but I don't think there's been much progress in relation to those.
I'm sorry, I should have said obviously that we will provide follow-up written answers wherever we're not able to answer fully today, as a priority to you.
You finished, Chair? Yeah, thank you, Doug.
Thank you, Chair. Sean, thank you, and thank you for your team. It's a big portfolio that you carry. Look, delays in the criminal justice system aren't all of our ills, but they make up for an awful lot of them, if in truth. And you'll have heard me asking about the issues around victims and witnesses, and you'll know where I'm going in regards to that, and also remand as well. So there is a real issue here. And if I look at the processing data, the average time for charge case to be dealt with in the Crown Court from 561 days, an increase of nearly 5% on last year. I mean, that's an increase. With all that you're doing, that's increased. Is there a reason why that's increased? And secondly, have we considered that we actually need 7-day-a-week courts?
I think probably the biggest reason for increases that you refer to are the fact that this is a demand-led system, and it probably reflects a position which we're seeing in other jurisdictions as well, where there's just an increasing volume of business, which is a challenge. The process, the progress in relation to recovery is one that I'll look to Lisa to give some detail on this, which has been it hasn't been a linear improvement. We've seen on occasion significant improvement, but it is a dynamic figure, and it's one that is being affected by the volume of business. It's also dependent on changes that we're making through the Speeding Up Justice programme. Some of those are initiatives which will take some time to bear fruition. Lisa, do you want to update on where we're at in terms of recovery and times?
Yeah, and I suppose there's a couple of factors there to your question in terms of some of the driver of an increased time could be things around complexity and the increase in digital evidence. There could be a range of factors there. And court service colleagues may be able to speak next week to some of the points around the sort of 7-day-a-week courts, because I know through COVID there were the Nightingale courts and the overnight courts, and as part of the remit of the Magistrates Court work stream, part of that will look at whether or not we could do things like specialised courts, you know, so for example motoring offences carry a lot of volume in the system, so we could look at things like that. But I suppose the balance of that is also to run courts on that nature will require resources, both in terms of money and people. So I think we did reach a point sort of coming out of COVID where we actually found we had enough money probably to drive the courts, but what we couldn't find was people. So, and again, courts colleagues will talk to that. So it is the thing of we haven't seen the injection of funding in the system to enable the courts to recover and to operate at that level. In terms of recovery timescales, those are very difficult to predict because, for example, we have been running with additional funding every year since COVID. That's due to come to an end at the end of March. We have no certainty over money into next year. If that were to recover, like if the money were to continue, if all the people were on the ground, we might see a magistrates recovery towards the tail end of this calendar year and Crown next year. But I would heavily caveat that with actually, without the resources and people, that timeline would go out for quite a number of years.
And I totally agree. I mean, this needs resource and it needs a workforce, but speeding it up in itself can save money as well. The longer these drag out, it costs us more. And you know, over 2 years to deal with sexual offences, you know, and compare that to GB, half the time. You know, Crown Court, 156 days, GB, half the time. You know, we are literally spending money, taking twice as long to do less here. You know, it's, and this is a conversation we had 3 years ago when I was sitting here, you know, 4 years ago when I was sitting here. I mean, I guess until we get that resource and that workforce in there, I mean, we're literally skimming the surface of what is a real deep problem here.
Although it is also important to recognise that there have been some gains in that space. And I mean, we've mentioned committal reform, the first stage of committal reform, which has had dual benefits. One, it's a much more streamlined process because you no longer need to go through the process of oral evidence being given at the stage of committal. So that's a smoother process. But it also has benefits for victims in that it avoids them having to give evidence twice. And giving evidence, as Jerry indicated, can be incredibly traumatic, particularly in cases of serious sexual offences.
Yeah, and I guess the point I'm making, so that you're absolutely right, that's a real positive, that's something we've worked hard on and got out the other end. But the opposite side of that is if you're a victim or a witness, you know, taking so long, your evidence is degrading, your mental health is degrading, you know, some witnesses end up not even giving evidence, so you end up losing a case, you know, so, but I get the point you make, you're absolutely right, thank you, Chair.
Does anybody else? No? Justin, go ahead.
Just very quickly, that figure, 757 days for time to complete cases where the main offence was a sexual offence. What percentage of those cases are sexual offences by men?
I have to be honest, I don't have that figure available.
I haven't got it in front of me, but we can write to you with that.
The reason I asked that is because I was at a Women's Aid conference, a very important Women's Aid conference last week in Newry, hosted by Newry Down Women's Aid, or Armagh Down Women's Aid. And the point they emphasise, it's almost a get-out for perpetrators being the majority of which are men, that it's called victims of domestic abuse and sexual violence, where it should be called victims of domestic abuse and sexual violence by men, because it just categorises it in a whole different way, and women feel a little bit more protected by that categorisation. That's something they felt firmly.
What I would say to that is, I mean, I think it's a well-known fact that the majority of sexual offences that come, serious sexual offences and domestic abuse cases are perpetrated by men, but not exclusively so. Women make up a cadre of both sexual offenders and perpetrators of domestic violence. Another point about...
should there be two categories? Should there be domestic violence and sexual abuse by men and domestic abuse and sexual violence by women, so that that's clear that there's a big weighing in one regard?
Sorry, if I may, Sean, I think that part of this falls on, I mean, the issues that women face in these circumstances, I think, are being addressed through the Violence Against Women and Girls strategy. I think we need to be really careful in these circumstances that I think men are form a third of the number of victims. So whilst the majority are women, there are significant numbers of men who still suffer from similar situations, and the difficulty is that whilst it's inordinately difficult for any victim to come forward in those circumstances, it's especially difficult for men to come forward. So I think we would be keen to ensure that whatever our line of questioning, we're trying to encourage that women are protected, that men are protected, and that anybody who is a victim of such abuse or violence does come forward and can have confidence in the system.
My point, Chair, with respect is purely around reporting and the weighing that the reporting gives. Okay. So
sorry, just also one further point, and I mean, Lisa made reference to it. One of the changing factors in dealing with sexual offences has been the dramatic increase in the amount of digital evidence that is concerned. This is looking at phone records, looking at computer records, computer histories, and forensic examination of devices is proving to be a really significant challenge. Now, it's one of the areas that people speculate that in coming years AI may make a significant difference, but currently a police officer has to view and look through devices containing thousands and thousands sometimes of images or text exchanges or whatever, and that's been a significant factor in complicating the prosecution of sexual offences. Julie, is there anything you want to add on?
Just I think that I think a lot of these issues are interlinked. I think the issues around digital evidence will also, in due course, there are interdependencies with some of the Commissioner's recommendations around disclosure in relation to complainants. So I think, as the Commissioner had previously said, there needs to be a strategic response that kind of looks holistically across the system at how a lot of these issues are connected. On the point about domestic and sexual abuse strategy and ending violence against women and girls strategy, obviously the department is working. We co-lead the development of the domestic and sexual abuse strategy with the Department of Health, and there are a number of other departments that are involved within that and are delivering outcomes under that strategy. And we recognise that there are huge interdependencies with ending violence against women and girls, and that violence against women and girls are disproportionately affected, but as Sean and the Chair have said, not exclusively affected by domestic and sexual abuse. I think it is right that there are two strategies, but just to give the committee an assurance that we are working really closely with the Executive Office, not to duplicate work under that strategy, but to make sure that the work is joined up and that it's aligned, and that we're recognising that the victims within all of those crimes will have multiple needs that will need to have a tailored response, and we're working as we develop our strategy to ensure that we're looking at how we can meet those needs and how we can tailor those responses.
Thank you, Chair.
Thank you. Just I have a couple, if I may, but they all relate to your report and things mentioned within it. And if I could just work my way through, I'll not detain you for any longer than necessary. The department was required to lay a draft of regulations around domestic abuse protection notices and orders on the 21st of February this year. Your report advises us that work is ongoing, and you will brief the committee in due course. But obviously, the requirement was there.
Yeah.
So could you give us a status update on that, please?
Well, the status update is that we are continuing to work through some of the operational challenges that are associated with those. The Chair may recall that these were provisions which were added at the amendment stage, committee stage. They're added as amendments at the committee stage of the passage of legislation. At that time, the Minister made representations noting that similar provisions were being brought forward in other jurisdictions, and there could be an advantage to seeing how they operated before we took the step of committing legislation. Certainly, the experience that we're hearing is that those other jurisdictions are now having difficulties operationalising those orders and notices, and as we're exploring them with our criminal justice partners, they're highlighting very significant issues with their operationalisation. We're working through those, but it's proving to be more challenging, I think, than advocates of those provisions would have anticipated. Julie, do you want to?
Yeah, I mean, it's exactly that. We have done a significant amount of work to prepare draft regulations, and we've been working on a project basis with other agencies. I think some of the issues that we're seeing, they're also, as Sean has said, they're emerging in other jurisdictions, and particularly in Scotland, we're aware that they're experiencing similar challenges. The volume of cases is estimated to be significantly higher than previously been anticipated. So there's issues there for the operational response. There's issues in terms of resourcing, but it's not just around the volume of cases. It's also around balancing the timescales within which you would need to respond within the criminal justice system to once a protection notice is made. That is particularly challenging, and that's important that those timescales are kept short, because it's about balancing the Article 8 rights of the person who's going to be issued a notice. So there are a number of operational issues that we are continuing to work through, that the Minister's continuing to consider. We had been working towards meeting that deadline, obviously, but we'd also within that recognised that the committee that you would want to scrutinise that legislation as well. I think we still have some way to go before we can resolve those issues, and we will come back to you with a fuller briefing in due course, but we are still really grappling with thorny issues.
I think it would be helpful to keep us apprised of where things are and what some of the issues may be with regard to that. Yeah. If we could move on page, on our pack, page 38, your report refers to the protocol for serious sexual offences cases involving children under 13, and that the extension of that was going to be subject to securing funding. Has funding been secured?
It hasn't. It's continuing to operate currently within Antrim and Belfast on a voluntary basis, so with no additional resource. The volume of cases going through is small, but where there has been a case progressed through under the protocol, it is delivering significant reductions in the time taken for those cases to complete. To expand that and roll it out would cut across a lot of areas, including forensics, in order to expedite those cases, and the funding just hasn't been there. So it's continuing to operate within those two areas. In addition, the organisations who are participating within that protocol, they've all agreed to, where there is a case involving a child under 16, they will endeavour to expedite those cases. It won't be done in the same way as the protocol. The protocol sets very, very specific and tight timeframes. So it's more about affecting and changing the culture and the approach to those cases to look for other ways to expedite these. And I think because of the resource implications involved within that under 13s protocol, I think some of the concerns would, if you were to roll it out without the resource behind it, then there could be a knock-on effect for other cases for older complainants, including within that age group between 14 to 16. So I think that's some of the concerns as to why it can't be rolled out further, but it is continuing to operate on that more limited basis.
I appreciate this is getting into some of the minutiae, but I think, bearing in mind these are issues raised in your report, I think it's important for us to have some grasp of the things that with which you're grappling. It was helpful earlier on, Lisa, for you to indicate what Causeway can and can't do. That was one of my questions, so that's that one ticked off. And Maura, the last one kind of is for you. Andrew, you're getting off easily today. Maura, just in the course of your report, there's mention of the reform of rehabilitation of offenders legislation. Could you maybe give us some, and specifically around reducing rehabilitation periods, could you give us some further information about that?
So there was a briefing to the Justice Committee in the previous mandate on plans to bring forward secondary legislation that would allow for the reform of rehabilitation periods. I don't have the precise detail in front of me today, certainly can write to update you further on that, but an order was to have been introduced just before the Assembly was dissolved. There was an issue raised by one of our legal advisors around potential issue relating to competence, so that was withdrawn at that time. So since then we've been working on a revised statutory instrument to bring forward by way of secondary legislation. That's been reviewed by both Office of Legislative Counsel and the Examiner of Statutory Rules, and they've raised a query over whether it might be more appropriate to bring those provisions forward by way of primary provision. So we're currently taking the Minister's views on a couple of options, either to progress by way of a secondary legislation, or we could include it in the first bill of the mandate, which we're planning to introduce hopefully this side of the summer recess. So in terms of handling and where we are, and that's where we are. But yeah, the legislation was to give effect to provision that would allow for convictions to be spent sooner. And we took the committee through the consultation that had been run on that and the proposals that were being put forward, and the committee at that time had expressed themselves content with the department's proposals, but obviously we would want to brief this committee again on what we're proposing to do.
No, that would be lovely. Thank you very much indeed. Appreciate that, and thank you for that update. I suppose the last area that interests me is the inquest into death abroad. You have flagged up some concerns, but it strikes me that given that there is such provision in the other regions of the UK and in the Republic of Ireland, those issues may not be insurmountable, and obviously that causes considerable trauma. And there have been a number of cases, albeit a small number, but even so, we seem to be the only area without provision in that regard, and maybe you'd come back to us maybe in writing with regard to that. Does anybody have anything further? No? On that basis, could I first of all apologise to you for the delay in bringing you forward? But you can appreciate the issues surrounding victims are very important for all of us. Thank you for taking the time to brief us today. It's been really helpful. No doubt it will not be our last conversation, and thank you for your time.
Thank you very much, Chair.
Thank you. Yes, Chair.
Before the Bar Council join us for the next session, I want to declare the fact that I met with the Law Society and the Bar Council this morning with a view to setting up an all-party group on access to justice. That's been the topic of today, but specifically as they're likely to be our next item. And I would encourage members around the table to consider joining that as an all-party group going forward.
Thank you, Stuart. I met with them too, not today, but previously. And thank you for declaring that, yes, it affects me too. And also, I suppose, before we receive this briefing again, I would like to declare that I have an immediate family member who works in the legal profession. So we move on to agenda item 6, which is the Bar of Northern Ireland and the Law Society of Northern Ireland. A number of us have met previously. I would refer members to page 70 to 99 in their packs. So we are about to receive a briefing so that members of the profession can provide us some background on their roles and talk to us about the issues in the justice system. I know that one of you has been unable to make it, but in front of us, members, we have David Mulholland, who is the Chief Executive of the Bar of Northern Ireland. We have Maura Smith, KC, who is the Chair of the Bar of Northern Ireland, David Lavery, who is Chief Executive of the Law Society, and Darren Toombs, who is President of the Law Society of Northern Ireland. And we have now received apologies from Brian Archer, who's a Senior Vice President of the Law Society. Ladies and gentlemen, you're very welcome. Thank you very much for coming. Appreciate that there are 4 of you, and I understand that Maura is about to give the opening presentation. Again, we've made some time back, but we're keen that we should have as much time as possible to engage in a conversation, so perhaps 10 or 15 minutes of briefing and then we can move to questions. Is that all right?
That's right.
That's lovely. Thank you very much.
Thank you, Chair. So I'm pleased, along with the Chief Executive of the Bar, David Mulholland, to take the opportunity to brief the new Justice Committee so early in the mandate. The Bar recognises the important scrutiny, policy development and consultation function that this committee has, and we welcome your efforts at a critical time for the justice sector. The Bar seeks to advance a positive, proud and strategic vision for justice, so it's important that we work constructively with you, and today we will highlight several areas of concern for the Bar around the administration of justice and suggest that the committee might apply its focus and scrutiny to these areas. We provided the committee with a succinct briefing paper ahead of today, and the paper hopefully has given you background information on the Bar of Northern Ireland and details on some relevant issues for us. But for now I'm going to provide you with a brief overview. The Bar of Northern Ireland and the Law Society appeared before the previous Justice Committee in February of 22. Then we sounded a warning around generational harm to the justice system in the context of a draft budget that proposed a net budget decrease in funding for justice. Indeed, under the terms of that draft budget, justice would be the only department to experience a net budget decrease according to the Northern Ireland Fiscal Council analysis. Many of the warnings that we sounded back in 22 have been realised. Today we see many of the issues are apparent in the health system, manifesting across the justice system. Long delays, a dedicated but stretched and pressured workforce, historic underinvestment in the system and the need for structural reform. A particular pressure point has materialised around extended payment delays in paying legal professionals for publicly funded work under the legal aid system. The Bar doesn't accept that payments to legal professionals should be slowed down as a budget management mechanism on the part of the Legal Services Agency, particularly when all other suppliers are typically paid by the Legal Services Agency within 30 days as a prompt payment practice. In choosing to apply payment delays as a budget management measure, we say the Department is placing barristers in a wholly unsatisfactory, unprecedented and unsustainable position whereby they, rather than the public purse, are effectively funding service delivery. This is creating hardship for many of our practitioners, unfortunately, particularly among our younger female barristers who can't wait up to previous projections of up to 6 months for payment. Many, unfortunately, have been forced to leave the Bar altogether or to shift away from publicly funded legally aided work. This means the Bar, despite proactively taking action to improve diversity, will be less representative of society and will face a generational crisis to replenish the pool of legal aid barristers. Barristers who might potentially retain a viable practice will be under huge financial and workload pressure, and ultimately this threatens meaningful access to justice for people across Northern Ireland, for all citizens, for your constituents, members of the committee. I would invite the committee to look at this issue further. We may indeed agree that, as pointed out by the Fiscal Council, the Department has been underfunded and their budget is under pressure. But the committee may want to ask why the Department's budgetary management decisions have resulted in delays in paying only one category of supplier, namely lawyers, whilst the others continue to be paid promptly. The committee may also want to examine why, given that the Department has been made aware of the damage the payment delay policy is having on the viability of the profession and access to justice, the policy continues. You have rightly previously recognised the demand-led nature of the services offered by legal professionals. Barristers are not responsible for the legal aid rates that they are in receipt of. Furthermore, they can't insert themselves into legally aided cases of their own accord. It's worth highlighting in this context that rates of payment for legally aided work have not been reviewed when they should have been, and they have now remained static for decades, falling chronically behind inflation. For example, rates for criminal legally aided work have, when adjusting for inflation, plummeted by between 47 to 58% since 2005. The system is in clear need of review. Accordingly, the Bar welcome the fundamental review of criminal legal aid being conducted by Judge Tom Burgess. The review takes place when the budget for legal aid in Northern Ireland has fallen significantly behind the level of public need and the necessary public policy of speeding up justice. The Bar has also been informed that the Department is preparing to launch a call for evidence as part of a civil legal aid review, and I know that officials briefed the committee on that last week. I would stress the need for the Department to engage meaningfully with the legal professions and other stakeholders if it is to deliver its strategic aims. Thank you for listening, and obviously I'm happy to follow up on any matters the committee might have. But now I'm going to ask the Law Society President Darren Toombs for his opening remarks on behalf of the solicitors' profession. Thank you.
Thank you, Maura. Good afternoon, everyone. As President of the Law Society of Northern Ireland, I welcome this opportunity to brief the committee on behalf of the Law Society of Northern Ireland. I hope that this is the first of many constructive meetings between the Society and this committee, as I believe we will have many aims in common. I'm the President of the Law Society, but I'm also a solicitor in practice and currently still in practice whilst President, so I'm balancing those two roles. I'm double jobbing. The last time the Law Society gave evidence to this committee was in February 22, 2 years ago. And during that session, David, our CEO who's with me, and Brian, who unfortunately cannot be with me, they challenged the budget that had been proposed, which would have caused generational harm, as Maura had said, to access to justice in Northern Ireland. Thankfully, helped by the work of this committee and representations from legal profession and others, that budget was never implemented. However, we're now 2 years on, and many of the core problems in our justice system remain unaddressed, and access to justice in particular remains seriously under threat. Ahead of this afternoon's meeting, the Society shared our Justice Agenda document, which I have a copy of here with the committee. I'm hoping you all have received a copy of that. This sets out our thinking on the key policy priorities for justice. In the interest of time, I'll only briefly mention some of the issues that we raise in the document. Access to justice is, perhaps unsurprisingly, at the very heart of it, based on the belief that access to justice is a key protection for the rights of our most vulnerable citizens. Essentially, what we are calling for here is realistic investment into this area. We welcome Judge Tom Burgess's appointment to lead the Fundamental Criminal Legal Aid Review. The Society will do everything we can to support this review, and we hope to see further independent reviews of civil and family legal aid too, as the situation facing our members doing legal aid work is extremely difficult. We want to see the legal aid sector put on a sustainable footing. I had hoped that Brian could be here to talk about his experience at the coalface of legal aid work. I was originally qualified as a legal aid criminal lawyer some 23, 24 years ago, and I worked in a firm doing that type of work for the first 3 or 4 years of my career. And I don't do it anymore, but somewhat shockingly, when I look back, the rates for legal aid are almost the same today as they were 22, 23 years ago when I worked in a small local practice in West Belfast, a high street firm. Upholding the rule of law is another key theme for the Society. Unfortunately, in recent years, we've seen a rise in attacks on legal professionals for simply doing their jobs. We are therefore proposing measures to increase support of the rule of law. This will include the Rule of Law Pledge, which we will shortly be launching. This is a pledge to uphold the rule of law and the independence of the legal profession. We hope that the Justice Minister and the members of this committee will agree to support this pledge. We would also hope that going forward from that, all members here in this building would support that pledge. One final theme is justice reform. We have a situation where cases are taking so long to come to court that victims are giving up hope and withdrawing, so we know something is deeply wrong. Our key message here is that we desperately need to break down silos and see greater collaboration. Justice does not sit in isolation. It impacts and is impacted by health, housing, education, just to name a few. Consequently, if you get justice right, you see the harm. I'll say that again. Consequently, if you get justice right, you improve outcomes in those areas too. And if you don't get it right, you'll see the harm spread too. So we're calling for joint working by all relevant stakeholders to come together to improve outcomes for society. That feels like an appropriate place to conclude these opening remarks, and I look forward to further discussion on these topics, or indeed anything else that the committee would like our input on. And at some point there was a reference in the last meeting to 7-day courts, and I might have a few comments on that.
Fair enough, I thought you might. So, members, Morris.
Thank you very much, Chair. I hope it pleases you to know I'm against 7-day courts. 6-day I'm all right with. But anyway,
there already is 6-day courts, plenty of Saturday morning courts.
Yeah, I'm all right with that. Leave Sundays alone. Listen, I'm a great believer that if you have a bill, pay it. And I'm a wee bit disappointed that the legal profession, according to your own figures here, have got up to 26 million in unpaid bills in 22 and 23. That is a disgrace. If the Assembly here and our department really value justice, then we've got to pay our bills. We've got to pay our bills on time, and that has to be factored into the budget. I agree with you 100% that the justice budget is nowhere near enough for this department to work efficiently and for us to carry out our duties efficiently. So I would agree with you in that. Could you expand on your thoughts on the trainee support scheme for legal practices, and also give me a wee bit more background into your proposals for your rule of law pledge?
Okay, well, I'll take the bit on the trainee support pledge, and maybe David will follow up. So as well as being a solicitor in practice and the president, I'm also chair of our education committee. So I do look after the area that looks after young trainee solicitors. And what we're seeing is that the larger commercial firms, like the firm I work in, are not prepared but are financially able to take on apprentices, whereas some of the smaller legal aid firms, they just aren't. I mean, an apprentice will cost you over the course of 2 years of training probably somewhere in the guts of £50,000 if you were to pay them the minimum wage or even the living wage for their time in training over the 2 years, and some firms are prepared to pay their training fees whilst they're at the institute. So that could be, as much as £50,000, and a small local legal aid firm simply can't pay that. Now the result of that is that firm does not have a trainee following through, can't afford to have a trainee following through. Those are predominantly the firms which do the criminal work out there in the communities, providing the on the spot support for people when they're arrested, when they're taken to the custody suite, when they first appear, maybe on a Saturday morning in the local court. They simply don't have the trainees at the moment. What we would hope is that there's a scheme in Scotland which was aimed at supporting criminal practices, legal aid practices, to take on trainees. Now, within our law society, we've recognised that some young people have difficulty coming into the profession, and lack of finances is seen as a barrier to entry to the profession. So just last year we gave 2 bursaries to pay the fees of 2 young people who otherwise couldn't afford to pay it. So if we as a law society, a members organisation paying fees in, can see the need for something like that, we would hope that maybe the committee here could see the need and could strategically think as to how something like that could be brought about. 1 or 2 or 3 trainee solicitors, and I suspect probably outside of Belfast, in particular in places like County Fermanagh where they have no trainees. I think, David, there are possibly 1 or 2 other counties. I think South Down, where I'm originally from, I don't know that they've had a trainee train in any of the local practices in quite a few years, and particularly in the criminal area. It just isn't enticing young people in. One thing we're also seeing is that, if you unfortunately happen to be arrested for something, the solicitor who will turn up in the custody suite for you is probably going to be someone over 40 and probably even someone over 50. It's not going to be someone in their 20s or 30s. It just isn't coming through. We also saw recently one of the leading criminal legal aid firms in Belfast, very well known name for the last 50 or 60 years, closed down within the last month or 2. Sorry, that was probably far too much from such a short question.
So maybe I'll follow up with more.
Can I just comment on that? In relation to that, and this is just coming from in the neighbourhoods and the communities, and knowing a lot of young, given my kids, they're all in their late 20s, but a lot of their friends studied law. Mm-hmm. They've all been attracted into the private sector because of their analytical skills and the financial, particularly even my own kids, at the likes of financial services. They're not seen as attractive. So there's obviously a piece of work to do, particularly in Derry. We have fantastic law degree programme, young graduates coming out, but they're snapped up straight away into the likes of pharmaceutical companies and the likes of research companies, and particularly the likes of financial services, because they're paying a real good salary and it's local and it's a 9 to 5. So I'm conscious, obviously, there's a bigger piece of work regarding the profession and how we can encourage and support.
What I've brought with us, sorry Maura, I just want to mention this, we've brought with us this report on the solicitor profession, which if the clerk agrees I'll leave with you. That will give you a lot of interesting information. There are about 3,000 solicitors in private practice at the minute in Northern Ireland. More than half of them are now female. When I started training many years ago, there were 17% of the class were female. This year it's 71%, so it's becoming a female profession. And their expectations are different, and they want to go and work in large commercial firms because it's just a better offer. So we've got this remarkable economy where you have two extremes. You have Belfast has more large international law firms than anywhere outside the City of London. Quite remarkable. And then we also have these alternative legal service providers as well, who are hoovering up graduates by the 100. And on the other hand, half of our firms, just over half of our firms, are still 1 and 2 solicitor practices. And they're the high street firms. Now our problem is if we don't sustain the high street firms, and legal aid would be one of the income flows that they will need. If we don't do that, they will go. In the introductory remarks, colleagues have said we were last here 2 years ago to talk about the budget. In that period of 2 years, there's been a 7% reduction in the number of firms, and they're the small firms. I talked at the last meeting about Fermanagh had 16 firms altogether, and that will shrink. If we don't fix this and reset the whole system, you'll not have the high street firms. You will have the deserts of where there's no access to legal help. So we've great opportunity to fix this. Lots of people want to do law. There are lots of people doing law at university. Our 2 universities are producing fabulous people. The head of one of these alternative legal service providers said to me she would bring all of their international legal work to Belfast if she get all of the jobs recruit all the people she needs. And the 3 reasons: they're well educated, they've got a sort of work ethic, they know a day's work, and thirdly, well, frankly, maybe the salaries maybe about half what it would be in London, but it's still like a £50,000 salaries for a new entrant is remarkable. So we've got an economy of extremes. The commercial guys will be fine, they will look after themselves, I have no doubt. But it's the high street solicitors and the local access to justice is probably the biggest problem. I'm sorry, I cut across.
If I can maybe build on those points from the perspective of the bar. We have 20 admissions per year through the Institute. It's merit-based. And we are finding that the places are filled and the new barristers come to the bar annually. And there's about 50% male, 50% female. But unfortunately what's happening is at years, between years 7 to 10, there are high rates of attrition. Those talented young people who are coming to the bar aren't able to stay. And disproportionately, it's women that are leaving. And unfortunately also, they are leaving for a whole lot of reasons, but some of it is related to the payment delays, and the fact that they can't sustain a livelihood because they're not getting paid A, enough, and then B, having to wait far too long for it. So we're losing our talent, unfortunately, and we need to find ways of retaining them.
And briefly, just to supplement that, I want to reassure you that we have been trying very hard to broaden the intake into the profession. We have always had a tradition of financing the early years in practice. The first 7 years that one is at the Bar Council funds your library fees for you. We've added to that in recent years by working with Queen's on its Bright Futures programme. We want to see first generation barristers who believe and can truly experience that it is a profession that's open to them. But colleagues have covered it. The difficulty is without any financial certainty, which is particularly always a challenge in a self-employed profession like the bar. It's very difficult to retain the talent that we are attracting. And then there's the, I suppose, indirect issue. We're all talking, and nobody's disagreeing, that the system is in crisis. You mentioned, Ciara, about the alternative routes people could go, the other professions which seem attractive. We need to be mindful that if we only talk about a system because it only ever is in crisis, that's not going to be an aspirational route for people to take, despite what we think, and you heard it in Moira's introductory comments, we want a proud vision for justice, and we think the committee can help us in that regard.
There is something very odd though, sorry, forgive me. Half of the people training today at the Institute at Queen's will leave private practice within 5 years. That there's something wrong. We're training people to leave after 5 years, and they're mostly women leaving it. So we're trying to put in, say, a returner programme, so that women who qualified as a solicitor can come back into practice and make it easy for them to do that. But that's a remarkable statistic. For every 100, 50 will have left private practice within 5 years of qualifying. So that clearly needs to be addressed, and it's probably partly Queen's need to help us, we need to help ourselves, but you can see that's a very strange number, isn't it?
I'm acutely conscious that the original question was Maurice's, so I would like to afford Maurice the opportunity to come in if he has any supplementaries.
No, just if you could give me some information on the rule of law and pledge, but listen, we're constrained by time, and I'd be happy to have it sent to me or some way.
Well,
thank you.
We've been very concerned about the attacks on lawyers. In Northern Ireland, we know only too well what that can lead to. And there have been a lot of instances of it in the last number of years when even the Prime Minister is standing up and saying lefty lawyers representing, immigrants, that sort of thing. When a national newspaper can call the Supreme Court the enemies of the people. So we think it's important to try to hold everybody to a certain standard where you don't blame a lawyer for representing an unpopular cause. You recognise that everybody needs legal representation, whether the person you represent is popular or not. So we've developed this thing called a pledge, Maurice, and we're going to ask if Naomi would sign it to begin with, and then we will share it with others. It's an undertaking to uphold the rule of law and respect the independence of the legal profession. And we think it's okay. It won't maybe make a dramatic difference, but it's a standard of behaviour you can hold people to account against. And I'd say
Thank you, Maurice. Deirdre?
Yeah, no, thanks very much for your presentations. And I suppose the issue of legal aid, there's no doubt we'll come back to engage us in more detail on, because it has come up at this committee a few times. Obviously, there was the set discussion last week. We know there's the JR, and they didn't get into details in terms of that, but we are concerned, and we're hearing it obviously from the profession on the ground in terms of the delays that it's having. Obviously, in your presentation, how that impacts certain sections of the workforce, and particularly around family law as well. So even within the crisis or opportunities within the system itself, there's those who are more disproportionately impacted than maybe others as well. So again, we'll want to probe and to get into detail of that. And particularly the impact of women into the profession as well. And we know that it's not just unique to law, there's other sectors within our society that are impacted on this. And obviously trying to build a rights-based approach at the heart is going to be key. So I actually seen the Bright Future programme with Queen's, and I think that's really good, because I think on the one hand we need to deal with the challenges, I agree, but we do need to offer hope and opportunity of what the system could be at its best in trying to attract and retain skills that are there. And as you say, the universities are really producing. I suppose some of the things I was going to ask was around that issue of diversity and well-being and inclusion. So legal aid, there is one huge chunk of it, so it's to get a sense of is with the current system of legal aid, I suppose on the one hand, how you are engaging with the Tom Burgess review. I think you said about the department not engaging sufficiently, so how could that be improved in terms of the engagement? And then also around more widely in terms of diversity and representation, even within the legal profession, what more can be done? Obviously payment's a key part of it in terms of people's income, but what more can be done or to be reflective in terms of class, gender, minority ethnic, because obviously we're hearing other reports where there's an increase in representation coming through the justice system of some of these groupings. Even those with disabilities as well, what more work needs to be done, and what you see as the barriers then in terms of access or attraction to those for a workforce within the justice system more broadly. There's probably not enough time, but we will definitely come back on the legal aid stuff because I think it is key. And just even the manifesto or the justice agenda, I think sits very much with some of the things that we have been discussing. So definitely want to come back on those issues too.
There's some time, there's 15 minutes. So.
Do you want to say anything first?
Certainly happy to pick up some of that, maybe taking in reverse order about the question about how we're trying to improve diversity and participation in the profession. Without repeating everything we said, I mean, certainly in our case, our route into the profession is totally merit-based. People do the institute exam. We don't know the gender, name, background of them, so it is entirely merit-based, and we are committed every year to taking at least 20 people into the profession, so that shows our commitment to doing so. But we do recognise, as I said, that we need to probably start at an earlier stage in the journey to tell people how they get to the institute, why they might want to get to the institute. So that's where really our work with Queen's on the Brighter Futures programme came in. But in addition to that, which we somewhat covered earlier, we're trying to give some representation of existing role models, and particularly to this point that has required us to give particular emphasis to gender leaders in the profession, female leaders in the profession, including Moira. And we've done a range of things like that. We have tried to make a positive report on the recent KC appointment scheme, which had the highest proportion of female KCs that we've ever had in any of those calls. We, if you were to visit the court building and the Inn of Court, you would see we have photographs of all female KCs to try and counteract what up to that point had been maybe a traditionally male landscape, if you like, and this is trying to promote that you can only be what you can see and trying to encourage people in that direction. We have a lot more to do in some of both in gender diversity and some of those other demographic issues that you highlighted. But sitting around all of that, we've done a lot of work about trying to change the culture and the values around the legal profession. We have, for some time now, put an emphasis on, as you would expect us to, calling out and having proper procedures about any bullying and harassment. But in the last 12 months, our bar went further than that and said that there can be an environment which is just off-putting, where it's not maybe as overt or as defined as bullying and harassment, but it's unreasonable behaviour, including unreasonable demands, not taking account of somebody's other commitments in their life and so on. And we've put together procedures for that to be flagged, to be anonymously raised with the Bar Council, so that we can petition about issues like that. So, very quick answer is we're trying to go right to source and encourage a wider intake. We're trying to support that intake when they get there. We're trying to inspire them through celebrating Pathfinder role models, and we're trying to change the culture as well.
Yeah, and can I just add to all of that, we have really good mentorship programmes in the Bar Library as well for women, for younger people. We have particular networking events for women. Tomorrow morning I'm hosting an International Women's Day breakfast where barristers, male and female, can take in other friends or family, and it's again just giving women their place at the bar, and even in terms of our breastfeeding suite, we're trying to change the culture and make it a family-friendly working environment for women. Again, to retain these really very brilliant women at the bar, at practice, because it's a self-employed profession, it's challenging, it's arduous, and we want to create as supportive an environment as possible.
Deirdre, just on the Law Society side, we did a diversity and equality survey 2 years ago, and that tells us what I think we suspected. Most people entering the profession parents have a university background, so that's why we introduced the centenary bursaries. That's a small step, but it's paying £10,000 to each recipient to help them access training. A couple of other things. You mentioned the Burgess Review, and I'm not sure if I misspoke or you misheard, but we're not criticising anybody about the Burgess Review. The department have set this up. We welcome it. It's led by a senior judge. I think it's exactly the right way to go about reviewing criminal legal aid. We would, as Darren said, we would like a similar independent approach to civil and family legal aid. And the other thing, just to mention on legal aid, it's not all just about fees, it's also about who's eligible to get legal aid. For civil and family legal aid, there's an income threshold and a capital threshold. Those thresholds have not been increased in the capital terms for 30 years. We're disenfranchising whole swathes of the community. You have to basically be on benefits to get access to legal aid now. There are people on lowish incomes who are simply unable to access it now. So you're going to end up with justice being either for people who are have very, very low incomes, or people that could afford to go to law themselves. And that's what the system was not designed to do that. And by not increasing those eligibility thresholds, we're taking lots of people out.
Is there any research available, up-to-date research reports on those that are just above the threshold and then unaffordability, so it puts those off accessing justice?
We're doing a lot of research at the minute, and we'll be able to share that with you, because we want to demonstrate the value of legal aid socially as well. So as soon as that's available, we can send it to the...
If I may, just one brief final maybe remark on the Burgess review, because as David has rightly clarified, we really welcome the fact that there's an independent review, but I think it is important to stress that that review comes after an absence of statutory reviews. So there is a heavy burden on that review in addressing a vacuum which has existed around any review of fees for some time, and Moira quoted what that has meant in terms of real terms cuts. And of course, we don't know yet whether the recommendations of the Burgess Review will be approved, and if they are approved, when they will be implemented. So there is a lot of expectation resting upon this review. It's of critical importance to the profession because it is addressing an area where there has been no activity and no decisions for literally decades. And if there was any scope for interim recommendations to address some of that historic period, we would certainly warmly support that.
If I could just go back then on the education, or sorry, on the entry to the profession and widening access. I mean, I was lucky enough all those years ago to pass the 11 plus, and I came from a working class background and ended up in school with Justin here. He was a year above me, so luckily I didn't have to play against him on the football field. But no, I feel that sliding doors went the right way for me in my career, and I was a tad lucky. Okay, so I got my 11 plus. I went to a school. I went to a grammar school, and out of that grammar school, they would push people towards professions. They would push you to do your A levels, to become a solicitor, to become a doctor, and they would push you in that direction, and they would show you that those were opportunities open to you. So that doesn't start necessarily with the profession, although we are reaching out. That starts, and this is where I was saying break down the silos up here. Education, the education department, reach out to them. There probably are some schools that kids are at where it's not even, it's not shown as an open pathway to them. And there are probably some schools in the past, I suspect, that when some people thought of law and enforcement and law and order, they might have thought of joining the police. They never in their wildest dreams thought of going and becoming a solicitor. So those, I think, speak to the guys in education as well, and there's a piece there, educating people, showing people where they can get to if they strive and work hard enough, that the door is open. There is no bar to entry into the solicitor's profession. It's like the bar. You do your degree, you do an entry exam to the institute. That's is merit based, and people can move on. It's getting the young people to a position where they can then access that, is it? And that starts so early on.
Right. If I could just kind of remind members that I have a list and there's a running order, and if we can kind of move through that, Justin.
Thanks, Chair. Thanks, folks, for your evidence thus far. You mentioned, Moira, about your assertion around the payments delay policy as a budget management measure. Mm-hmm. Is that not a serious assertion to make against the department, presumably?
Well, I think it's accurate, Justin. At the moment, I think, as you'll see from our briefing paper, there's actually a live judicial review case where the professions have brought before the court the issue of the lawfulness or otherwise of the policy that the department has of delaying payments to the professions as a measure of budgetary control. So what happens is, we heard in the other session that the speeding up justice policy has led in some instances to our courts having greater output. Everybody's working harder, more cases are being disposed of. However, the budget is fixed for a demand-led service. So although the barristers and solicitors are working harder, because there's a fixed budget, what has been happening is that the department at times have had to slow down the rates of payment so they don't run out of money, which means that barristers and solicitors have to wait longer to be paid for work done. Now that is having a crippling effect on barristers. And Justin, it is disproportionately affecting our young people, our people who come from backgrounds where there isn't, family money, and it is unfortunately also disproportionately affecting women. The very people we want to retain in our profession, so we have a representative group of barristers for the people they serve and they represent in court. So that it's not something that it's not a glib headline. We have been living with this experience for years, and unfortunately, taking the judicial review, and as you'll see in the paper, our 1 day of withdrawal of services on the 17th of November past is symptomatic of a profession that is being brought to its knees because the impact of payment delays is affecting the sustainability of those groups of people in particular being able to remain at the bar. It's really quite serious. It's a very serious
situation. It's self-defeating in terms of the delivery of justice as well.
Pardon?
It's self-defeating in terms of the delivery of justice.
And I mean, the need remains to be met. All it does is defer it into a future period, and that's why you have £26 million now sitting as an unassessed bill. So if you think about it, bills are put on the long finger or the credit card to be paid at some day. But that means that even if there is an increased budget available, that's the first claim on that budget, and it doesn't really take you any further forward. So it is absolutely factual that this is a budget constraint situation. And we agree entirely, as Moira said, that traditionally the justice budget has been underfunded. On that, we're on common ground. Where we disagree is that this is a reasonable measure to respond to that budget, because it seems to uniquely affect lawyers. And I think it's important to stress, of course, we need to get that message strongly across about our members for all the reasons that Moira and Darren and David have said. But we are only there to serve other people, your constituents, and the cases that are going through court and the delays are in the court system. So if we can't do that, those situations only get worse. But it is not only already bad, it is, depending on what the next literally weeks derive in terms of a budget outcome for the coming year, potentially about to get much worse.
And some of those fees are fixed fees. They're fees for work done. It was agreed several years ago when legal aid reviews were carried out that some fees were reduced a little bit, but they were reduced on the basis that if a barrister or a solicitor put it in, that was a part of a case. It's done, it's dusted, it's signed off, it's in. It's really just to be paid. So it's not even a matter that some of these fees are fees that need assessed or somebody needs to check out where the hours put in, because they're not. It's a fixed piece of work at an agreed rate, in it goes. That shouldn't take 10, 12, 14, 16 weeks to assess and pay. That should be an automatic. Court service can say that was done, that barrister did turn up on the day, that solicitor did turn up on the day, that was a plea on that day, the case was dealt with, bump, pay it. I mean, that's 3 or 4 weeks.
The system Darren is describing is called standard fees, and I was in the department that introduced those way back in 2005, and the deal was, as Darren describes it, you would have a standard fee for a particular type of work, and it would be paid promptly. And the reason it could be paid promptly was we went every year to the Treasury and asked for additional money, and we got it, because it was the way the system was funded. When they transferred responsibility to Stormont in 2010, we lost the ability to go directly to the Treasury to get topped up, because they were topping up the system in England as well. We were just a sort of small example of that. So trying to hold a demand-led service, the demand for which is expanding on the basis of a fixed amount, it just isn't going to work. And I think the department recognise that every bit as much as we do. So this exercise that we're undertaking is an opportunity to try to reset it. Because the department, when they gave evidence here, they said legal aid has never been properly funded, not since 2010, and if we don't fix that, we'll not be able to fix the downstream consequences of it, unfortunately.
Can I just also mention this? We know from liaising with colleagues in other jurisdictions that, certainly speaking on behalf of the bar, our colleagues in other jurisdictions don't have to wait the length of time that we do here in Northern Ireland to be paid for work done on the basis of legally aided work. So there's systemic problems here that need to be addressed because of the crippling impact on the profession and the wider impact then on access to justice.
Can I ask you, in terms of the plan for better justice, Darren, upholding the rule of law and the delivery of a Bill of Rights for Northern Ireland, what's the implications of that in terms of the CHR rulings potentially, and also addressing the legacy of the past, and how does the legacy bill having passed through Westminster impact the ability for justice here to address the legacy of the past?
I leave that one to David. I have to say that I am not a constitutional lawyer at all. David is much better placed to answer that than I am.
That's called a hospital pass.
That's called a hospital. That's called a hospital question.
Well, we've been very critical of the legacy legislation, as you know, and we obviously note the decision of the High Court and the fact that there's now going to be an appeal from that. We particularly regret the removal of the legacy inquests and the other forms of access to justice. We, in a way, just need to see where this ends up once the court challenges are over. On the Bill of Rights, in principle, we have been supportive of the principle there should be a separate Bill of Rights for Northern Ireland in addition to the Human Rights Act, and that's even more imperative, I guess, when the government, certainly the current government, is quite hostile to aspects of the European Convention and talk about, stepping aside or withdrawing from parts of it. So, in principle, we would agree with the desirability of that. We feel that a codified set of rights is something that works for the people of Northern Ireland. We're quite familiar with arguing for rights and responsibilities. So, in principle, we agree with that. I'm not sure I would say it's our absolute number one priority. I think fixing the basic system is the biggest priority at the moment, whether it's speeding up justice to get justice for victims and survivors quickly, or whether it's addressing the funding deficit so that you have a sustainable legal service, you have legal providers available to you. If we get those right, we can build on that, but there's an opportunity now that you're back to try to address what has been about 10 years of underfunding since the transfer in 2010. Now, we've been lucky in one respect. We've had very progressive justice ministers. I think I should acknowledge the work that David Ford, Claire Sugden and Naomi Long have done. They didn't make bad decisions such as were made in England. They took private family work out of the legal aid system altogether in England. It's caused absolute havoc. At least we didn't do that. We've retained the scope of the legal aid system in Northern Ireland for those types of cases. And that's one of the benefits of devolution. Otherwise, the English policy would have been applied here and we would have gone down the same road. So we've had many advantages to devolution. It's just the funding hasn't been put in place to match it, I think, is the primary concern we would have at the minute, and the impact that's going to have on the supplier base of lawyers, whether they're barristers or solicitors.
Members, I'm conscious that we're already over time. Stuart?
Just very briefly, I guess this is where the rubber hits the road, because the reality is the impact of a payment-led system hitting the impact of a budget, and the not inconsequential impact of 2 years of nothing happening in Northern Ireland. That's where you're at. You do now have a minister. These issues are on the table and hopefully can now be addressed, but they will only be addressed not only through the understanding of the minister, but when that minister makes her arguments for the appropriate budget to be delivered. So this isn't just a justice issue, this is a finance issue, and this is an issue which we as an Assembly and the wider community has to address in terms of the budget. And in a sense, I'm sympathetic to the fact that you are at the end of the day the trade unions for the barristers and the solicitors in Northern Ireland. That's what you are. You're their representatives and their voice. And I think it is important that people should be paid and paid fairly, and that using you as a battering ram in part of that is somewhat unfair. But what is the alternative? Because the alternative is, if those payments were not delayed, then quite simply, some people would get paid and some people would never get paid. So spreading the load and sharing the pain has been where the department has taken you at the moment. I hope that going forward, and hopefully we get a budget and we see the way through out of this in the next 6 to 12 weeks.
Can I give you a little real-life microcosm example?
Absolutely.
Because sometimes real-life examples hit home better than all of our chat. David and I were up at the Limavady Solicitors Association dinner last Friday night in the Roe Valley. And there were about 11 or 12 solicitors there in that association, small association. Their court was closed over COVID, remains closed. They're not sure if it's going to open. Their local custody suites are closed. They can't bring young trainee solicitors into the town because they can't afford to bring them into small firms and train them. The last trainee they had, I think, is about 7 or 8 years qualified, and one of them is actually now a principal in his own firm that he's taken over from his father. So it's not just this. Forget about lawyers' pay. This isn't just about lawyers' pay, because so we've got a court there that's closed. That's a local court. We've got a custody suite that's closed. That's a local custody suite. So we're having a delay, simple delay. Solicitors phoned for. They don't just go to their local custody suite. They have to maybe drive 45 minutes. So there are police officers tied up waiting for the solicitor to come from maybe 45, 50 minutes away, instead of maybe even being able to walk to the local custody suite. You've got the local people who are appearing in the petty sessions. Most of the people who appear in petty sessions do not have their own car. They're reliant on public transport or taxis to get there. So, you look in Belfast petty sessions, most people come and walk in. People are then having to go to Coleraine or Derry or further afield. So then people aren't turning up for court because they maybe don't have the money to turn up for court. And what happens if you don't turn up for court sometimes? There's an arrest warrant put out for you. So someone's ended up getting arrested simply because they can't afford to get to court. So there's just a wee real-life example.
Very briefly, Chair, that exactly sets out the whole condition of where we're at, and that spreads across not just the Department of Justice, but all departments. A consequence of delay, a consequence of poor management across the years of budgets here in Northern Ireland, and those are real-life consequences of where we're at.
And if I can, very briefly, because I know about the time, just in terms of your question, Stuart, I think we should always remember that legal aid certificates are in the name of the particular person in need of legal representation. It is, in my view, part of the welfare state, and it needs to be demand-led, because people who get legal aid certificates are families in need. For example, I'm a family lawyer. Children, families who find themselves in the care system, for example. And if it's not properly funded, you're going to have, long delays, people leaving the profession, and unfortunately then, the type of people leaving the profession who we want to retain to be representative of the people that they serve.
And while the aim of budget predictability is one we can all logically understand, I think care has to be taken at what that means in real terms. It means, why would you bother with new strategies about violence against women and girls? Why would you pass progressive legislation about domestic abuse, which are intended to address an unmet need? And by its nature, an unmet need, once
it's going to deliver more.
It's going to give you unpredictability that you didn't have before. So I think the committee would be well advised, just like our suggestion about look further than just a headline about no budget. What do people mean when they want budget predictability? Do they mean need will be deferred, need will not be addressed, issues will be suppressed just to fit within a budget? Well, the ramifications across society of that are extreme.
Absolutely. No disagreement here.
Okay, I think that my lesson from this is, as chair, I should probably ask my questions first.
Sorry.
No, that's fine. Look, I have met with each of you before. You'll be aware that I'm highly familiar with the issues that you face. I live those issues day and daily. But what I'm hearing from you today is that there are issues around delays in payment. That those delays in payment can be the difference between a firm having to close or a firm being able to carry on and provide a service, or people having to leave the profession entirely. I hear that. I hear that there are issues around the rates of payment, and that for 10 years, none of either the rates of payments or the thresholds for access to legal aid have not been reviewed. And those, again, are causing consternation, so we understand that. I further appreciate the fundamentals of attracting people into the professions. It strikes me that in circumstances where a tradesman can name his price, a good tradesman can name his price, that in circumstances where people are trying to access justice because they are entitled to a defence, they will struggle to find service, and that the service is in decline because young people naturally want to go to the corporate aspect where there is money to be made and where they're not going to have to go to a police station at 3 a.m. So I understand all of that. There are a couple of things. I take on board the budget predictability issue, and I think that that's important, David. I think we'll bear that in mind. There are a couple of things that I would like you to come back to me on, please, if you may, because I'm conscious that I don't want to pursue it any further. One is around, excuse me just one second. One is around the apprenticeship situation. Previously, apprenticeships were paid at well, maybe placements is more the issue. I think that there are issues at present for people who can secure places to the institute if they can get a placement, but they can't get a placement because solicitors' firms can't afford to pay them the wage. Now, previously, people were paid for the times at which they were in the solicitors' offices and not for the times at which they were training at the institute. And maybe there needs to be a look at that again, but I appreciate that apprentices are entitled to payment, but maybe there are issues around that we can look at. The hours are an issue, I think, but certainly I would like you to come back. I would like your side to come back to me on apprenticeships and payments. That would be helpful, and I would like, if I may, if the bar side would come back to me with regard to the Burgess review. I think that there's a thorny issue around brief fees. The solicitors are fairly straightforward in that they have particular rates for particular activity. The bar has an element of that, but there are brief fees, and brief fees cause problems for everybody. I think it would be helpful to have some understanding as to the extent to which brief fees are going to be included in the Burgess review, and more than that, if you could give us some indication as to how brief fees are calculated. Because I appreciate that you've come here today together, and I appreciate that there are many factors that impact the profession together, but also you have significant differences, and you have issues. You each have issues that you need us as a committee to understand, and to understand the distinctions, and I think that that's important. So at times we may seek that you come as individual groupings, but in the interim, could I thank you for your presentations? I think it's been really important that we air those, because access to justice and the delays in the justice system are a massive part of the work that we're trying to get our heads around. Thank you for contributing to the conversation. We do value the work that you do for our constituents, and no doubt we'll hear from you again in due course. Thank you very much.
Thank you.
Thank you.
And yes, if you would leave your documents, I think all of us would be happy to see that. Yes, that's us all set for tonight. Thank you. Okay, members, if I can turn your attention to agenda item 7, which is SL1, the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, Order Northern Ireland 2024. And I would refer you to pages 101 to 112 of your pack. Members, the Department of Justice proposes to make a statutory rule using the powers in the Coronavirus Act 2020 to further extend the provisions to allow courts and statutory tribunals to receive evidence wholly or in part through the use of audio or video links. The rule will also permit a court or tribunal to make arrangements for all or part of a hearing being conducted by live link to be broadcast, or for a recording of the proceedings to be made. Members, I would remind you that the committee noted correspondence from the department at last week's meeting, which advised that the Minister is satisfied that there remains a clear role for the continued use of the provisions to tackle the backlog of cases that accrued during and since the pandemic. The Department also advised that it is the Minister's intention to include permanent provision for the use of live links in its first bill, which it plans to introduce before the summer recess. The reliance on the powers in the 2020 Act is therefore an interim arrangement, and I think we can all welcome that. Having considered the response from the Department, the Committee agreed that it was content to recommend that the previous statutory rule should be approved by the Assembly. So I'm asking you your views on whether you're content with the proposal for the statutory rule to further extend the live links provisions for courts and tribunals, or if any further information or clarification is required. And if I may on this one, I am going to go first. It struck me within the course of the correspondence that there may have been some degree of misunderstanding. I don't think that there is a dispute around the need for live links. That's not the issue. The issue is one where I think all of the committees at this stage are somewhat frustrated at Department's dependence on emergency legislation through the Coronavirus Act, which was necessary at the time, but didn't necessarily have full scrutiny and so on, and we're constantly revising and reviewing and renewing. The issue in this circumstance is that the Minister has indicated that she will bring forward legislation around live links prior to the summer recess. It would be helpful to know when, because I think it's fairly clear to say that will be brought as part of a bigger and wider piece of legislation that may take some considerable time to scrutinise. Therefore, it is likely there will be at least one further extension, perhaps two. So I suppose it will be helpful for the committee to have some understanding, whilst we remain sympathetic to the circumstances in which the Minister finds herself, and we welcome that it will come before the summer recess. Still, I think we all have difficulties with perpetual extensions of coronavirus legislation. It would be helpful to understand what consideration was given to bringing forward a standalone piece of legislation around live links, because there are issues with live links around consistency of application and around equality of arms, which I think we would want to be considering in any scrutiny of whatever legislation does come forward. And when exactly the Minister does consider that such legislation around the modernisation of justice will be brought forward. I understand there's an official in with us today. Yes, if either of you would like to give us some advice on this.
Thank you, Chair. You spoke too soon when you said I was getting off early, or getting off easy this afternoon. But
I think it was more Andrew was getting off lately today.
Just to introduce my colleague, Moira Sheehan has been doing the heavy lifting in terms of making provision for live links, both on the temporary basis through the extensions and also preparing the way for new primary legislation. And I thought it might be useful for me to speak just about the handling of the legislative programme, given I'm taking the lead on that. So, as it said in the Minister's letter, the plan is to include provision in the first bill that we want to bring forward for this mandate, which we're hoping to introduce this side of the summer recess. As you say, Chair, that's going to have quite a bit of content in it, and there is a written briefing on its way to you. You'd requested when Richard Pengelly was here a bit more information on the legislative programme, so we will be setting out in that response the content that we anticipate will be in that bill, and no doubt we'll be here plenty of times in the future just to talk further about that legislation as it passes through. But we do intend to make provision through that for live links. But because of the size and scope of that bill, we anticipate it could be around about 12 months to get it from beginning to end. Then it'll be a couple of months before we will get royal assent. So just to be upfront about the fact, this is not going to be a quick fix, but it's the quickest we can do it on the basis of using that vehicle. So that will require further extensions in the interim if we want to maintain the current provision, which we are keen to do. The Minister is keen to do. She recognises it is far from ideal that we're having to make these extensions. We don't want to be relying on legislation that was for a particular purpose. But given that we need primary for these provisions, unless we have new primary provision, we would lose that, and that would mean us defaulting to the position we were in prior to 2020.
I suppose the key question more is what consideration was given to bringing forward a standalone bill with regard to live links, as opposed to given the need, as opposed to incorporating it into a much larger bill, which is going to take considerably more scrutiny and considerably more time to pass through the Assembly.
I think it's given that there is such a backlog of legislation that we want to get through in this mandate. We did present the Minister with a number of options for the legislative programme on her arrival. She had indicated her priorities were a sentencing bill and hate crime bill, and given all the provisions that we need to bring forward in a modernisation of justice bill, that's enough to fill a whole mandate. We had at one point, you may recall, looked at having a smaller bill around children's bail and remand to start the mandate, and then followed up by a modernisation of justice bill. But when we looked at the time frames, that wasn't going to allow sufficient time at the end of the mandate for a hate crime bill as well. So when we were presenting options to the Minister, the option she preferred was to try and cover off as much as possible in a modernisation of justice bill, and then have a sentencing bill followed by a hate crime bill, which may also be an opportunity for some victims provisions to be included. One of the issues we're looking at, for instance, is could that be a vehicle for putting the Office of the Victims Commissioner on a statutory footing, which was something the Commissioner was talking about earlier. So yeah, it's just trying to fit, I suppose, a pint into a half pint pot in terms of the legislative reforms we're trying to get through, and that was why the plan was to include it in a modernisation of justice bill.
Or is there anything you want to add?
No, I think other than to say that you've heard from the legal profession just there, and all our engagement in terms of how live links has benefited users, in particular those at the lower socio-economic areas, the impact of courts and relying on public transport, and the difficulties, even most recently with the announcement of Dungannon being closed, Craigavon where it's moving to, and that all the engagement, and most recently in the 2023 engagement, so many, we got 42 responses to that engagement, which is a high level when you're sending out, and all were saying it's retrograde if we lose these. For those with caring responsibilities, many made comments about the difference it made, and that
I think on that,
and the option.
I don't think there's any question around the need and the desire. I don't think there's any issue there. It's more about process, really.
Yeah, and the absence of any other alternative is really what has us relying on the coronavirus, and otherwise we wouldn't be relying on it if we had an alternative primary legislation like the Department of Communities have identified. We don't, and that leaves us in this position.
Yes, although I suppose there's a choice to be made about bringing forward a standalone piece, but we've made that point already. Did you want in?
No.
I thought you did. Must have been the way you're holding your pen. No, that's fine. Right, I think we've...
Sorry, just in the spirit of transparency, the plan is to include provision at consideration stage of the modernisation of Justice Bill, and just to explain why that's the plan. It still means we have the legislation in place within the time frame as if it was in at introduction, but basically over the past 2 years we've been monitoring developments elsewhere. We need to go back to the Minister just to update her, which we've recently done, just on some further sort of policy considerations that we need to finalise before we would instruct Council and have provisions drafted.
Maura, just before you come in, Maura, could I just put you over that again? You're saying the plan is to introduce this at consideration stage?
So to include those provisions, the draft provisions, in the bill at consideration stage rather than on introduction.
So post-committee stage?
Well, we would plan to share the draft clauses with the committee for committee stage so that you would have the time to see those. So it's just a practical issue around how quickly we can have the provisions drafted.
There's a limited resource allocated to working on the live links policy, and there is also, with the Minister returning, some additional changes that have been made in other jurisdictions in Scotland, and that might have a benefit here in Northern Ireland, but which weren't in place in beforehand. There's a toing and froing that happens with Legislative Council, and the time scale to get that between it would not have met when the modernisation bill was moved forward to fit in 3 bills from the Department of Justice, would not have allowed for that to and fro, because it's got to cover the full spectrum of the courts, the criminal, the civil, the family, and give the Legislative Council all the background. So it's, at the moment, it's all very, shall we say, where live links are, they're all over the place in different legislation with different tests. There's five variations in criminal. So we have been working on moving towards instructions for Legislative Council, but they're not ready to go immediately. Legislative Council has what he needs for the start, but the agreement is that they will be worked on to get to him in time for them to be shared, for the committee to have consideration, but to be introduced post consideration.
I think, Chair, as long as the committee has an opportunity to consider, and that is vital. Yeah. Particularly, and I think I'm interested in the fact that the live links and other methodologies will be at the new edge of where we are, because a lot of this was predicated on technology that was brought around during the coronavirus. A lot of it is Zoom and Teams and stuff like that, and various other systems that are out there and available. But if you're looking at, for example, the Scottish experience and perhaps other experiences, we're going to have legislation that will deliver a better quality of service. And when we listen to the Victims Commissioner today, to let this drop would be a disaster.
It would certainly have major implications for victims of crime in particular.
Again, I would reiterate, I think that we all understand the need. Yeah. The issue is that the process is concerning, and now that this has come to light, it is increasingly concerning, because as far as I understand, in terms of our processes, in circumstances where it isn't included in the original format of the bill, we can't call for evidence on something that hasn't been brought forward. So we can't now, and this is part of the issue, the live link issue, because, in terms of what I have said previously and what Mara has said, there are significant issues of consistency. There are issues about equality of arms. It is a significant piece of work for the Department of Justice and towards transforming justice. However, it's not without its pitfalls, so I think it would be important that it would be scrutinised properly and effectively in a way that it was not, because it was part of emergency legislation. So again, this does not relate to the need or the requirement for live links. No. It is about proper and adequate scrutiny. So it is most disappointing and most unusual to have circumstances where that would be brought forward at that stage and not included at the start of the bill. And I think that probably should be reflected back to the department. Ladies, please, if I may. I mean that's concerning. It's not a small issue. It is significant, and it is right and it is necessary. However, it is not without its issues, as you have highlighted. Therefore, those issues should form part of any call for evidence from this committee.
And I wanted to give you the full picture today.
And I very much appreciate
Chair, rather than waiting until you receive the correspondence. And I think it reflects the fact that, as Mr. Dixon says, this is really about modernising justice. We want something that is going to meet future needs, so we want to future-proof it. We didn't just sort of copy and paste from the Coronavirus Act. We wanted to make sure that the policy is fully worked through and takes account of experience to date over the last number of years across all jurisdictions that have been using live links. There was a public consultation which closed shortly before, I think it was September 2022, so shortly before we lost ministers in the Assembly. So we have a bit of catch-up to do in terms of finalising the policy. We want to get it right, but certainly we will make every effort to have the clauses available to you at the earliest possible opportunity.
Yeah, but you'll appreciate more that even them coming at the earliest possible opportunity for us means that they can't be included in circumstances where we're calling for evidence on a bill. And
I do appreciate that
that's
point.
difficult from our perspective, because there are stakeholders who should be involved in that conversation. Does anybody else have anything that they want to add or ask on this?
I think the important thing, Chair, is that we do have what might be described as an imperfect vehicle, but we do have a vehicle which will allow us to continue the very important work of live links. That should not be lost in this argument at all. Unlike other departments can fight and argue their own battles. But I think for us, we've had first-hand evidence today of the importance of continuing to deliver this, even though, and I agree with people, the vehicle for delivering it is not a perfect one. We then need to cross the bridge of what has been described to us, and I welcome the openness and transparency of the department being very honest with the committee today and setting this out. And I hope that the conversation, Chair, which you have had, will go back to the department and we can work our way around this so that there will be that full open consultation as well.
I do too. I mean, look, on this one I think it's disappointing. I'm grateful for your candour.
Yeah.
I think that we would like to do our job effectively as we the Minister. It's not a small issue. We've already highlighted that. But it would be our preference that it was considered in the normal way. The other thing is that if this is how it's going to proceed, okay, but I would not like this to be the modus operandi as to how the department is going to continue with the other pieces of legislation and other parts of legislation coming forward to this committee, because I think we need to be assured that we can gather as much evidence as possible and scrutinise effectively to help the Minister to form better legislation. Deirdre?
Yeah, no, none of this is easy, so we appreciate that. I was just going to ask in terms of, you'd mentioned more a letter coming from Richard. Is that setting out the legislative programme, and will it go into detail in terms of how the proposed bill for a permanent fix to this, but including other stuff, will that all be contained within that letter? Sorry, just...
He was asked for, well, there were a few points of follow-up from Richard's appearance, so there's a letter coming from the Departmental Assembly Liaison Officer to the Clerk, which will cover off a number of issues, including a fairly brief update on the legislative programme in terms of the bills that we intend to bring forward, but we also thought it might be useful for you to have a list of the proposed content of the Modernisation of Justice Bill, and then there will be further briefings, obviously, as we go forward on the detailed content. There's quite a lot in that bill, so I think if we'd included a lot of detail on each element of it, would have been sending you a PhD dissertation at this point, which might be a bit much.
I mean, I'm happy in terms of, for me today anyway, that this part of it in terms of the extension goes forward for all of the reasons that have been said. Obviously there is a concern of how the more permanent fix is going to be phased in terms of that engagement and scrutiny part of it. So again, if there is a way that you can take that away and see if there's anything at least can be front loaded or brought forward when it can, understand all the reasons you're given in terms of trying to look at best practice elsewhere and making sure you are future proofing it, because it is such a successful scheme, and you know we'll want to do more of that. But just, I suppose, to listen to the concerns of the committee on that particular element of it.
I'll take the point that the Chair has made, and we'll look to see in terms of maybe how early we could brief you on the proposed policy and maybe expand more on how that's intended to work, which may assist with taking views from stakeholders.
Oh, yeah, well, thank you. Thank you very much.
Thank you.
So members are content then with the proposal to extend the statutory rule?
Read.
All right, thank you. Agenda item 8, the Police Pensions Remedial Services Amendment Regulations 2024, at page 113 of your pack. So the Department has provided advance notification of its intention to undertake a consultation on amendments to the Police Pensions Remedial Service Amendment Regulations Northern Ireland 2023. The Department notes that no provision exists to permit police officers to transfer their pension into the legacy scheme. Regulations were made in January to facilitate this in England and Wales, and the Department intends to replicate those provisions here. So the consultation paper will be included in the agenda for our next committee meeting. Are members content to note the paper and consider the matter further at the next meeting, or do you require further information or clarification at this stage?
I'll be dealing with it at the next meeting.
Yeah, lovely, thank you. And the forward work programme then is agenda item 9. Yep. I just want to draw your attention that there's stuff in the tabled papers of that as well. And as always, some of those dates will change dependent on the availability of witnesses. The Department has added in some additional pieces of work that you'll see in your table papers. Are members content? Is there any issues to raise? All right, thank you. Item 10, correspondence. So there's a correspondence memo and 4 items at pages 127 to 150. I'll draw your attention to a couple of items and then you can have the opportunity to comment on any further issues. So item 2, which is at page 133, is from Jenny. They've conducted an inspection of forensic services in Northern Ireland, and the report is there for members' perusal. Are you content to note this item and request confirmation that the Department and all other relevant bodies have accepted the recommendations and details of timescales for implementation?
Great, yeah.
Thank you.
Yeah. It was just a point, sure. We'll raise it when the police and stuff are in, but it was just around whether we're adjoining some of the services. It noted in it that there were concerns from the PSNI, so I think it would be good to get an indication as to what they are.
Yeah.
And they were saying about they couldn't be effective then until 2030. So just we could maybe pick it up when we're meeting the Chief Constable, or give them advance notice, you know, if that could be answered.
Yeah, because there's a lot can happen in 6 years.
Yeah,
quite right. Okay, item 3, which is at pages 142 to 147, which is a copy of correspondence from the Minister of Health to the Committee for Health regarding the Human Tissue Act 2004, which is supply of information about transplant regulations 2004. Could I ask that we note this item, if you're content, and ask the department for further ask our department for further information on the aspects of the statutory instrument that fall under its remit? Members content?
Agreed.
All right, agenda item 11 was chairperson's business, of which there is none. Do members have any other items of business they would like to raise? No, thank you very much. The date and time and place of the next meeting. Members, the next committee meeting is due to take place next week with a provisional start time of 2 p.m. Could I ask, if possible, would members agree to facilitate a 1:30 p.m. start for that meeting?
Next week instead
that,
of you?
yeah, would that be okay? That's great. Thank you very much.
I'll let R2 know that I'm too.
Thank you.
I think
Committee Room 30, sound.